All right, guys, now we're just waiting for the all clear to get started. All right, guys, I know y'all are probably tired of staring into a camera, so if you want to turn your cameras off until we get the all clear, I'll bring y'all back up and let you know that we're ready, okay? Thank you for your patience. Hey, Phil.
Hey, sorry for the interruption. Juror Rusomano, can you hear me?
Yeah, I can hear you.
I need to move you to a different courtroom. I need to move you to courtroom number 7.
Okay.
So if you don't mind just logging off of this and logging back onto the website and entering courtroom 7.
Okay, same password?
Same exact process. Yep.
Okay, thanks.
Thanks.
Take care.
All right, advocates, just to let y'all know, we're getting close to where we've confirmed everything. So just be ready here in the next couple of minutes and we'll get started. All right, we just got the all clear. So if I could get all my advocates to turn their videos back on. All right, everyone's here and we just received the message to get started. So we're gonna go ahead and call the case of State of West Carolina v. Timothy Ray. My name is Judge Seal. Scoring judges, please look to the two buttons on the lower left of your screen and make sure that your audio and video is turned off, and they should remain off until trial ends. You should also have your video set to hide all non-video participants. This means the only people on the screen right now should be the advocate and me. Jersey, if you have any issues, please let me know now. All right, we're gonna go ahead and get started. Can the attorneys please make appearances, starting with the state?
Good afternoon, Your Honor. My name is Zachary Green, and that's Green, and I'm present with my co-counsel, Joseph Cassib, that's Casseb, and we represent the state in today's proceeding, and we have a few housekeeping matters to attend to after defense introduces themselves.
Sure.
Good afternoon, Your Honor. My name is Avery Hitchcock, appearing on behalf of the defendant, Timothy Ray, and today I'm joined by my co-counsel, Mr. Blake Barrich.
Good afternoon, Your Honor. Blake Barrich appearing on behalf of Timothy Ray.
All right, good afternoon to all of you. All right, State, you said you had a couple of pretrial matters. Let's go ahead and take that up now.
Yes, Your Honor. As we've not had the privilege of practicing in your court before, our first housekeeping matter is to confirm that for today's proceeding, we're using the Federal Rules of Evidence and the Federal Rules of Criminal Procedure.
That's confirmed.
According to Rule 615 of Federal Rules of Evidence, may we assume that all witnesses are sequestered, except, of course, for both parties' expert witness in this case?
You may assume that. Defense, I'm assuming you want your expert in the courtroom during the proceedings.
We have no objection, Your Honor.
Okay.
Your Honor, may we have permission to stand during opening arguments and closing arguments and while questioning our witnesses?
Yes, absolutely. I'd prefer you stand. I know this is a different competition. I've done this a couple of times. It's the first time I've ever had to do one like this. So however you feel comfortable, if you need to sit in some places, whatever you guys want to do to feel comfortable, it's fine with me.
Yes, Your Honor. And because this court has issued time restraints of 55 minutes per each side to present their case, may we assume all witnesses have been constructively sworn in?
You may assume that, yes.
And when publishing exhibits to witnesses, would you prefer that we request before doing so?
Publishing exhibits, yeah, let's ask before we publish, and for my purposes.
Yes, Your Honor. And may we assume all sidebars when requested are made outside the presence of the jury constructively?
Yes.
And throughout the record, there have been previously marked exhibits for identification purposes. We ask that those exhibits retain those markings throughout the trial.
Yes, we'll adopt the pre-marking system that was used in the case file, with each side referring to them by their letters and numbers.
And may we assume that the jury charge has been read to the juries prior to closing arguments constructively?
You may assume that.
Yes, Your Honor. This concludes the state's housekeeping matters at this time.
All right. Does the defense have any housekeeping matters they want to take up before we get into opening statements?
Your Honor, we don't have housekeeping matters. However, we do have one motion in limine that we'd like to argue if we may.
Okay. Let me ask first with the state. State, do you have any motions that you want to take up with the court now?
No, Your Honor, but we will respond to the defense's motion in limine.
Of course. All right, defense, let's hear your motion.
Your Honor, at this time, we'd like to move for the admission of Exhibit 15. This is a pretrial deposition transcript of Dr. Sam DiGiuseppe, a medical expert who both sides stipulate is unavailable for today's trial. This pretrial sworn testimony was taken in the presence of both parties, and both parties had a full and fair opportunity to cross-examine this witness during that deposition, knowing full well that she would be unavailable for court today. Because we'll be using this document throughout our case today, including our opening statement, and because this is textbook former testimony under 804B1, we move for its admission at this time.
Okay, I don't have any issue with pre-admitting the deposition, but I am going to give the state an opportunity to object to any portions of that deposition at this time. So, Mr. Green?
We just ask that this record not be allowed to go in front of the jurors doing opening examination, because we argue that we have not had the opportunity to form a motive as is required by Rule 804B1, and we don't know which statements may be elicited during opening or whenever this exhibit might come in. So we do object.
All right, well, if I understand Mr. Hitchcock's motion correctly, they're moving to admit that entire deposition transcript into evidence. Is that correct, Mr. Hitchcock?
Yes, Your Honor. In response to what the state just said, they did have full motive to develop this testimony because they knew full well that she would be unavailable today. They had the opportunity to cross-examine and in fact did cross-examine her. Therefore, this argument that they didn't have a motive is in bad faith.
Well, we'll hold off on the bad faith arguments right now, but I want to say that I understand and I hear your argument, but Mr. Green, what I'm telling you is they're moving to admit the entire exhibit. I agree with Mr. Hitchcock that you did have the opportunity to cross-examine these witnesses at that time, but I'm giving you the opportunity now to object to specific portions of that deposition transcript, and we can take up those specific objections one by one. If that's what I'm assuming, there are some portions that are going to be admissible, but if you have any portion of the deposition transcript that you want to object to now's the time to do it.
No objections at this time, then, Your Honor.
All right, well, without objection, I'm going to constructively admit Exhibit 15 into evidence and assume that it has been put into evidence. And we need to pause for just a second, guys, because now I have a juror trying to come back in. So give me 1 second before we start opening statements. And while I'm doing that, do we have any other motions from the defense?
No, Your Honor, just the one.
Okay, well, give me 1 second before we start opening statements and let me figure out what's going on with this juror.
Oh, good, Nail. Sorry about that. I do know how to operate Zoom. I'm just having bad, bad experience today.
That's perfectly okay, Juror Waldenberg. I appreciate you getting back in. We have gone through our motions, and we are about to proceed into opening statements. I have a script that I need to read first, so give me a second. We will now hear opening statements from each party. Everyone should make sure they are in speaker view. That button is in the upper right portion of your screen. Attorneys, please remember to mute your audio when the other attorney is speaking. And with that said, State, you can proceed with your opening statement.
Your Honor, just one moment while my co-counsel and me switch rooms so he can give opening, if that's okay.
Certainly fine.
Your Honor, the state is ready to proceed.
Go ahead.
May it please the court, opposing counsel, members of the jury. Help me. Why are you doing this? I want my mommy. Those were the last words of 6-year-old Timothy Ray before his father put a belt around his neck and squeezed until he stopped breathing. Members of the jury, when a parent kills a child, we ask why. Well, over the course of this trial, we'll know why the defendant, Timothy Ray, committed the murder of his son, Nathan. But in order to do that, we need to start on that day, October 17th, 2018. See, little Nathan, he walked into the kitchen and he saw on the kitchen table a bowl of Frosted Flakes and a glass of apple juice. This was Nathan's favorite breakfast. But what Nathan couldn't see was that his father, there was tension coursing through his father's veins. Now, sure, Nathan did know some things. He knew his mommy had moved out of the house, and he only spent some of the days with her and some of the days with his father only. But what Nathan didn't know is that his father was a volcano ready to erupt, and the evidence will show that when Nathan accidentally spilled that glass of apple juice, it was enough for his father to erupt. The defendant shouted at Nathan to go to his room, and he commanded him to perform jumping jacks and high knees and other physical exercises. And Nathan, poor little Nathan, he was confused, he was scared. So he shouted, "Help me, why are you doing this? I want my mommy." The defendant heard that. He heard that his son wanted the woman who had walked out of their house, and he wanted her. So the defendant, he went to his room, and the evidence will show he grabbed that belt. He went back into Nathan's room, and he put that belt around Nathan's neck. And Nathan, he screamed, and the defendant, he squeezed. And Nathan, he cried, and the defendant, he squeezed, and he squeezed, and he squeezed until Nathan stopped breathing. Members of the jury, I represent the state of West Carolina. That means I represent each and every one of you. That also means I represent Nathan's mom, Jessica. And as the state, I need to prove to you that the defendant committed the murder of his son with malice aforethought, and I need to prove that to you beyond a reasonable doubt. The judge is going to instruct you what those terms mean. He's going to tell you that malice aforethought means that the defendant intended to and willfully killed his son. That when you hear malice aforethought, you can think premeditation. And premeditation has three things. The first of which, did the defendant consider killing his son? The second of which, did the defendant make the decision to kill his son? And the third, did the killing arise from that decision? Now, there's no specific time requirement that goes with premeditation. It can be a month, it can be a minute, it can even be a millisecond. And the evidence and the testimony will show that the defendant committed murder with malice aforethought. Now, as the state, we have a burden. Our burden is to prove to you beyond a reasonable doubt the defendant killed his son. The judge is going to instruct you that when you think beyond a reasonable doubt, you need to think act without hesitation. Based on the testimony you'll hear today and the evidence you'll see, you will feel confident in acting without hesitation and finding the defendant guilty of murder. Now let's talk about some of that testimony you'll hear today. We've brought a witness here, a Detective Blake Booth. Detective Booth had been working with the Skelton Police Department for over 20 years. She was a police officer that the defendant confessed to killing his son. Detective Booth is going to tell you about the interview she had with the defendant and what the defendant told her happened that day and then the days after. The defendant told Detective Booth about the spilled juice, about the jumping jacks, and even about the belt. Detective Booth is going to tell you that the defendant told her that he buried little Nathan's body in Brandywine State Park. The defendant also told the detective about his wife leaving him. Detective Booth is going to tell you about recovering Nathan's body and how it was found in a black trash bag buried in a shallow grave. She's also going to tell you about the investigation she conducted. That included 3 searches, the first of which was a search of the defendant's house. Detective Booth is going to tell you that during her observation of the house, what she saw corroborated what the defendant told her during her interview. She's also going to tell you about a search of the defendant's phone. And in that phone, she discovered 3 internet searches. The first of which, how to get rid of a body. The second of which, will bleach destroy a body? And the third of which, what countries don't extradite for murder? Detective Booth is also going to tell you about a search of the defendant's vehicle. And in that vehicle, she found 3 relevant items: black trash bags, bottles of bleach, and a shovel that was later determined to have Nathan Ray's blood on it. Now, we've been put on notice that the defense is bringing an affirmative defense of insanity. Now, the defense will need to prove to you that the defendant was insane at the time he killed his son, and because of that insanity, he was unable to appreciate his actions. They also have a burden. Now, the burden the defense has is to prove that it was highly and substantially more true that the defendant was insane than untrue. But they won't be able to meet that burden because of our second witness, a Dr. Mac LaGreca. Dr. LaGreca has been a psychiatrist for over 20 years and has testified as an expert numerous times. Dr. LaGreca is going to give the opinion that the defendant didn't have schizophrenia. In fact, he was faking it. And how did Dr. LaGreca come to that conclusion? Well, based on all the evidence of the record and also of the observations of the defense's witness. See, the defense is going to put forth Officer Peyton Wentz. Officer Peyton Wentz is going to describe his observations that evening where he came into contact with the defendant after he killed his son. Now, Officer Wentz is going to say that initially, the defendant refused to provide identification. And it wasn't until after the defendant's identification was in the hands of the police that he began to ask questions like, "Are you with the CIA?" He began to perform jumping jacks, and he began to move his head around uncontrollably. Dr. LaGreca is going to say that is malingering or faking mental illness symptoms in order to receive some benefit. And that benefit is avoiding being charged with murder. The defense has also brought a second witness, and that witness is Dr. Shane Riley. Now, Dr. Riley is going to give the opinion that the defendant had schizophrenia and maybe even had it since he was a child. However, this wasn't the first time Dr. Riley saw the defendant. In 2010, the defendant saw Dr. Riley, and Dr. Riley gave the opinion that the defendant only had a general anxiety disorder. So what changed between 2010 and 2019? Well, the defendant killed his son. The defendant was charged with the murder of his son. And Dr. Riley started to get paid by the defendant's attorneys. Members of the jury, you will determine the credibility of these witnesses. Help me. Why are you doing this? I want my mommy. I want you to remember the last words of Nathan as we go on through this trial. Nathan is not here to ask you for help. He's not here to ask you for help because of the actions of the defendant on October 17th, 2018. Those same actions the defendant is trying to avoid responsibility for by claiming an insanity defense. But members of the jury, your state, the state of West Carolina, is asking you to find the defendant guilty. Thank you.
Thank you, Mr. Cassib. All right, defense, you can proceed with your opening statement.
Yes, Your Honor. They missed the signs. Timothy Ray is sitting in a doctor's office. He's been there before. The same curtain in the corner, the same clock on the wall, the time frozen in place. He keeps coming back because he knows something is wrong with him. Something has always been wrong. He tells the doctor, "I've never been okay." But instead of getting the help he needs then, Mr. Ray is allowed to leave. He never gets any medication. He never gets any help. He leaves that doctor's office like every time before, untreated. Now, members of the jury, what happened on October 17th, 2018 was terrible. A parent's worst nightmare. And to think that a parent could do this, it's unimaginable. No normal person would. But today, you're going to hear evidence that'll show Timothy Ray isn't normal. He's sick. Very, very sick. He suffers from schizophrenia. But the doctors, his family, his friends, they missed the signs. Because of this, we're bringing what's known as an affirmative defense, which means it's our burden to prove by clear and convincing evidence that Mr. Ray was legally insane. Now, what does that mean? Put simply, it means that when he killed his son, Mr. Ray didn't realize that what he was doing was wrong. We'll prove this to you by showing you two simple facts. Number one, Mr. Ray was suffering from schizophrenia, a terrible mental illness which makes people hear voices that aren't their own and have delusions that just simply aren't true. Number two, we'll prove that at the time of his son's death, this schizophrenia took control and caused Mr. Ray to harm his son. First, the evidence will show that Mr. Ray was suffering from schizophrenia years before any of this happened. You're going to hear from Dr. Shane Riley, a board-certified expert in forensic psychiatry. She'll testify that she reviewed Mr. Ray's history, did an in-person evaluation, and came to a conclusion. Mr. Ray had a family history of severe mental illness. He suffered from childhood trauma. Mr. Ray saw hallucinations. He heard voices in the years before his son's death. Mr. Ray had delusions about his wife's affair. And perhaps most importantly, you'll learn that the people around Mr. Ray saw him acting in stranger and stranger ways as the years went on. You'll learn that his wife saw him go through constant mood swings and that he got more and more isolated. Now, you just heard a story about malingering, but Dr. Riley will explain her thorough evaluation and this third-party corroboration led her to conclude that Mr. Ray was suffering from schizophrenia years before October 2018. That it got worse and worse, but everyone missed the signs. Second, we'll prove that at the time of his son's death, Mr. Ray was experiencing a schizophrenic break. He had delusions about his son and wife conspiring against him. He heard voices telling him over and over he had to kill his son. You'll learn Mr. Ray was still sick when the police found him. You'll hear that after his son's death, Mr. Ray was stopped by Officer Wentz at what was supposed to be a routine checkpoint. You'll hear it was anything but routine. You'll hear that Mr. Ray started screaming accusations of being CIA in one moment, and then in the next was silent with a blank stare. You'll learn this was schizophrenic behavior. But the evidence will show this behavior was ignored by the prosecution's witnesses. You'll learn that after Detective Booth interrogated Mr. Ray, she said, "You're a piece of shit, would be better off dead," and then allowed the only footage of this interrogation to be wiped clean. You'll learn that the prosecution's expert apparently didn't need this footage, didn't need to talk to Mr. Ray or anyone else. The evidence will show the prosecution had their minds made up. They missed the signs, they even ignored them. But you don't have to. Now, to be clear, Mr. Ray will regret October 17th, 2018 for the rest of his life. He was a father, and he lost a son forever. But the prosecution will try to say he knew exactly what he was doing. He knew it was wrong. The evidence will show that Mr. Ray isn't evil. He's sick. At the end of today's trial, my co-counsel, Avery Hitchcock, will ask you to find Mr. Ray not guilty. Thank you.
All right. Thank you, defense. State, are you ready to call your first witness?
Honor, the state calls Detective Blake Booth.
Good morning, afternoon. I just need to write the time real quick.
What?
Ready.
Detective Booth, would you please introduce yourself?
Hi, my name is Detective Blake Booth, and I work with the Skelton Police Department.
How long have you been a police officer?
I've been an officer for the past 23 years.
How long have you been a detective?
A detective for the past 8 years.
How many homicide cases have you worked on?
This will be my 12th homicide case.
Detective, now I'd like to talk about your interview with the defendant. Why did you interview the defendant?
Well, I initially interviewed the defendant because we were looking for his son, Nathan Ray. Jessica Ray had filled out a missing persons report, and nobody had seen Nathan or Tim for a while.
Referring court and counsel to Exhibit 29. Your Honor, may I publish Exhibit 29 to this witness only?
Yes, you may.
Detective, do you recognize this photograph?
Yes, I do.
How do you recognize it?
I recognize it because it is a photograph that Jessica Ray gave to me when she was filling out the missing persons report for Nathan.
Is this a fair and accurate representation of the photograph given to you by Jessica Ray?
Yes, it is.
Your Honor, at this time, the state offers into evidence Exhibit 29.
All right, any objection to Exhibit 29?
No objection, Your Honor.
All right, without objection, Exhibit 29 is admitted.
Your Honor, may I publish this exhibit to the jury?
You may.
Now, Detective, what did the defendant tell you happened on October 17th, 2018, that morning?
Well, the defendant explained that he and Nathan had been getting ready for the day when Nathan accidentally spilled apple juice on the defendant's computer.
Excuse me, could we take down this exhibit now? Now, Detective, what did the defendant tell you he did after Nathan spilled the apple juice on his computer?
Well, the defendant then described becoming upset and telling Nathan to go to his room to go ahead and do some physical exercises like jumping jacks, running in place, high knees. But the defendant was upset because he didn't think Nathan was doing them as best as he could be.
How did the defendant describe Nathan's demeanor at this point?
At this point in time, the defendant described while Nathan was doing the exercises that Nathan was screaming and crying, telling him that he hated him and he wanted.
Objection, Your Honor. 403, may I be heard?
You may.
Your Honor, we're not disputing today that Nathan Ray was killed by Timothy Ray. The question in today's case is whether or not the defendant was legally insane during this time. The prosecution's trying to use evidence about what Nathan said to inflame the passions.
May I interject? Are we being heard outside the presence? Are we?
I'm sorry. I'm sorry. Yes, we're outside the presence of the jury.
Okay. I apologize.
Again, Your Honor, this is being used for the sole purpose of inflaming the passions of the jury here, that Nathan Ray was a 6-year-old child screaming for his mommy. It has no probative effect as to what the defendant's state of mind was when he killed Nathan. And because of its outstanding unfair prejudicial effect, this is exactly the type of evidence 403 bars.
Mr. Cassett, what's your response?
Yes, Your Honor. We're using the statements of Nathan to provide the motive, and that goes to the defendant's state of mind, which is at issue here. The statements are being used to the effect on how the defendant responded to these statements. That's what we're using them for. They're highly probative because of what the defendant does after hearing these statements. There's no there's no highly prejudicial effect of these statements. They're just being used on what they made the defendant do.
All right, the objection's noted, but I'm going to overrule the objection.
So, Detective,
We are back inside the presence of the jury.
Detective, could you, what did the defendant tell you that Nathan had said while he was crying and screaming?
The defendant described that Nathan was screaming and crying, and while he was screaming and crying, he was calling out for his mom, telling the defendant that he hated him and why he was doing this.
So what did the defendant tell you he did after hearing those statements?
The defendant then described going from Nathan's bedroom into his bedroom to grab a belt and then coming back to Nathan's bedroom.
And what did the defendant do after he got back into Nathan's bedroom?
Well, because Nathan was still screaming and crying and calling out for his mom, the defendant decided to punish him, and he wrapped the belt around Nathan's neck and started squeezing until Nathan was no longer moving, no longer screaming.
What did the defendant tell you he did after strangling his son?
The defendant then described putting Nathan in his car and driving around before eventually burying Nathan's body in Brandywine State Park.
Referring court and counsel to Exhibit 19, Your Honor, may I publish this exhibit to the witness only?
Yes.
Detective, do you recognize this photograph?
Yes, I do.
How do you recognize it?
I recognize it because I was there when it was taken. It's actually a picture of Nathan's body as we recovered it from the park.
Is this a fair and accurate representation of photograph taken of the recovery of Nathan's body?
Yes, it is.
Your Honor, the state offers into evidence Exhibit 19.
All right, any objection to Exhibit 19?
Yes, Your Honor. Again, we object to 403. Considering that we're stipulating today that Timothy Ray killed Nathan Ray, how he disposed of Nathan Ray's body afterwards and being shown a photograph of the body in a trash bag in the park as it was recovered is again being offered solely to inflame the passions of the jury. It has nothing to do with the state of mind when he killed Nathan, which is the timing that matters today. And as a result, it should be barred.
Mr. Cassidy, what's your response?
Yes, Your Honor. This evidence is relevant because it can be used to rebut the affirmative defense of the defense. They're trying to say he has schizophrenia. Where and how the body was buried points to the mental state of the defendant, and he was able to why he did this points to his mental state, and we're using it to rebut their defense.
Your Honor, may I be
Looks
heard?
like you want to respond. Yes.
Yes, Your Honor. Schizophrenia is an illness that may not always be manifesting symptoms at any given time. Like most illnesses, depression, anxiety, it doesn't matter if you have depression or anxiety. It doesn't mean simply because you have depression or anxiety that every day you're feeling depressed. Same is true for schizophrenia. Since he didn't dispose of his body that day or even within a certain close time frame, the closest this happened was at least the day after. This doesn't go to his mental state when he killed his son, which again is the only relevant time period in this case.
Defense, I'm going to give you the last, or state, I'm sorry, I'm going to give you the last word.
Well, then, Your Honor, we argue that this goes to the weight, not the admissibility of this evidence. The jury can weigh what they believe that this evidence, the weight of it.
Okay. Objection is noted, but I do think this goes to the mental state and the consciousness of guilt. And I also believe that they are allowed to consider actions after the time of the killing. So I'm going to overrule your objection.
Your Honor, may I publish this exhibit to the jury?
Yeah, now this exhibit is in evidence and you may publish it to the jury.
And are we back in front of the jury, Your Honor?
Yes, we are.
So, Detective Booth, what are we looking at?
We're looking at a picture of Nathan's body as we recovered it from the park. It took about a team of officers about an hour and a half for us to locate the body.
Thank you. If we could remove this exhibit. So, Detective, what did you do after recovering Nathan's body?
After recovering the body, we immediately got a search warrant and conducted 3 searches, one of the defendant's house, another of the defendant's phone, and another of the defendant's vehicle.
Well, let's take those searches one at a time. Which search did you conduct first?
We started with the house.
And what did you observe during your search of the house that was relevant to your investigation?
Well, we observed 2 scenes once we investigated the defendant's house. The first being the kitchen where the apple juice was spilled on the laptop, and the second being Nathan's bedroom where the belt was still lying on the floor.
Referring court and counsel to Exhibit 27, Your Honor, may I publish this exhibit to the witness only?
Yes.
Detective, do you recognize this photograph?
Yes, I do.
And how do you recognize it?
I recognize it because that is a picture of the scene in Nathan's bedroom as we saw it when we investigated the defendant's house.
Is this a fair and accurate representation of the scene at Nathan's house as you saw it?
Yes.
Your Honor, the state offers in evidence Exhibit 27.
Any objection?
No objection.
All right, without objection, it's admitted.
Your Honor, may I publish this to the jury?
Yes, you may.
Now, if we could remove the exhibit as well. Thank you. So, Detective, you mentioned other searches. What was your next search?
We also conducted a search of the defendant's phone.
And what did you find on the defendant's phone?
Well, when we searched the defendant's phone, we found 3 internet searches that were particularly relevant for our case.
Referring court and counsel to Exhibit 10. Your Honor, may I publish this exhibit to the witness only?
Yes.
Detective, do you recognize this screenshot?
Yes, I do.
And how do you recognize it?
I recognize it because it was taken during our search of the defendant's phone.
Is this a fair and accurate representation of the screenshot you took of the defendant's phone?
Yes, it is.
Your Honor, at this time, the state offers into evidence Exhibit 10.
All right. Any objections to Exhibit 10?
Yes, Your Honor. Again, we object on 403 grounds. We anticipate that Your Honor will overrule this objection, but for the purpose of preserving for the record, we contend that this does not represent the defendant's state of mind at the time that he killed his son, because these searches happened the day after. And as a result, it's not the relevant time period in this case, and not the question that the jury should be asked to determine whether or not he knew right or wrong at the time. So for the purpose of preserving for the record, we object under 403.
All right, Mr. Cassim.
Your Honor, we will argue that this goes to the intent, to the mental state, and to the guilt and consciousness of the defendant, and that's why we believe it is highly relevant.
Yeah, I think mental state is an issue, so it's going to be admitted as well, and you may publish to the jury.
Thank you, Your Honor. Now, Detective, let's talk about the searches we found. What was the first search you found on the defendant's phone?
The first search was countries that don't extradite for murder.
And the second search?
How to get rid of a body.
And what was the third search?
Will bleach destroy a body?
Now, why were these searches relevant to your investigation?
Well, they actually took us into the defendant's vehicle and tied up what we also saw at the state park.
Well, let's talk about the defendant's vehicle now. What relevant items did you find in the defendant's vehicle?
Well, we found 3 relevant items in particular. One was a shovel that had blood on it. Another were jugs of bleach, and we also found black trash bags.
Well, why was the shovel relevant to your investigation?
Well, the shovel was relevant because when we tested the blood on the shovel, it came back as a positive match to Nathan's DNA.
And what about the black trash bags? Why were those relevant?
Well, the black trash bags took us back to how we found Nathan's body wrapped in a black trash bag.
And what about the bleach? How was that relevant?
Well, the bleach, we found those in the defendant's vehicle.
So, Detective, to summarize, based on your investigation, the recovery of Nathan's body, and these searches, what was the result of your investigation?
The result was we arrested and charged Timothy with first-degree murder.
Your Honor, no further questions at this time.
Understood. Mr. Hitchcock, your cross.
Yes, Your Honor. Detective, you think my client is a piece of shit who'd be better off dead, right?
No.
Objection.
Grounds?
Hearsay statements.
Well, Your Honor.
What portion? Go ahead, Mr. Hitchcock.
Your Honor, first off, this isn't being asked about any particular statement being given, although we may get into that if the detective gives a different answer. This is being asked about their particular state of mind and their bias. And as the lead detective in this case, their opinion of my client influences every decision that they later made in this investigation. So it certainly is something the jury ought to consider.
Agreed. Your objection's overruled, Mr. Cassim.
I'll ask again, Detective. You think my client is a piece of shit who'd be better off dead, right?
No, but that is what I told him during our interview.
That's right. After interrogating my client, you told him he's a piece of shit who'd be better off dead?
He had confessed to killing his son, and I knew his son. I knew him. It was overwhelming for me, and I let my emotions get the best of me.
I'm not asking why you said it, Detective. I'm just confirming that you did call my client a piece of shit who'd be better off dead, and you did.
Objection asked and answered.
Your Honor, and you
Overruled.
did.
Yes, and I never should have said that to anybody.
Now, like you just mentioned, Detective, your interrogation wasn't the first time that you met Mr. Ray, was it?
No, I had met him towards the end of August 2018 as well, because Nathan, his son, and my son were both in the same soccer league together.
That's right. So you would see him at soccer games and soccer practices.
Yes,
But even then, you didn't like the defendant, did you?
it was uncomfortable talking to him. He didn't interact much with me or really anybody else.
That's right. You thought he was socially awkward.
Yeah, that's how he appeared or came off to me.
Now let's talk about my client's behavior during this interrogation. According to you, nothing about the interview was odd, right?
No, primarily because he was making eye contact with me. He was answering my questions. So it seemed pretty standard.
And Detective, you'd agree with me that nothing that Mr. Ray said was odd during the interview, right?
Yeah, I mean, he was asking me about the CIA at some point, but I kept telling him we know each other.
Well, I'm not asking you to clarify your answer now, Detective. My question is whether or not you said that nothing that my client said during the interview was odd.
Yeah, it seemed he confessed to killing his son, and by the way he was reacting, I didn't have a reason to question it.
Your Honor, permission to publish Exhibit 3. This is part of the interview transcript. It'll be used for impeachment purposes.
Yeah, you can publish.
Let's talk about whether or not what you just said was true. Now, during the interview, the defendant asked on page 41, you asked, what were you and Nathan doing? And the answer you got was, are you from the CIA? You're from the CIA, aren't you? Nothing odd here?
Well, I mentioned that in my previous answer.
Well, how about this one then? Further on down the page, on page 42, it says, question, what happened to your laptop? Answer, it was because she tricked him. They told me she tricked him. She tricked him to do it. I know it. She tricked him to spill juice on it because she wanted to take him away from me. This made sense to you?
I mean, he was confessing to killing his son. I was primarily focused on trying to locate the body now. When the investigation started, we just thought Nathan was missing.
So back to my question, Detective, when you said the defendant didn't say anything odd during this interrogation, this made sense to you?
I had mentioned the CIA statements. Hindsight is 2020. This seems odd now. At the time, I was focused on locating Nathan.
So you'd agree that the defendant was saying odd things during the interview?
Now, yes.
Even though you previously testified under oath that he didn't?
Well, I wouldn't characterize it as that.
Detective, you do remember participating in a pretrial deposition for this case, right?
Yes.
And when you were deposed for this case, you were under the same oath that you're under today?
Yes. And
An
I'm
oath.
answering as honestly as possible.
And
Completely.
you did then too, right?
Yes.
You knew the importance of testifying honestly because of the gravity of the matters at hand today.
Yes.
So you made sure to tell us the truth then, just as you are now.
Yes.
All right, Detective, I'd like you to pull up Exhibit 1. This is your pretrial transcript, and I'd like you to go to page 44, lines 29 through, page 29, lines 16 through 17. Could you tell me when you're there? And Your Honor, permission to publish for the jury at this time.
Yes, Your Honor.
So on page 29, lines 16 through 17, you say that nothing the defendant said was odd. It was a normal interview, right?
Yes.
Thank you. Mr. Barrett, you could take that down. Now, going back to a moment ago, when we were talking about the last answer that we were exhibiting, he mentioned someone named they, right?
Yes.
You don't know who they are.
No, I do not.
You don't know who he's referring to when he says this ambiguous they.
No, he didn't mention anybody in particular.
But this isn't even the only time that he mentions this undefined they, is it?
I don't know. I don't think so.
Well, no, because further on down the page, he says, question, how did that make you feel? Answer, I didn't mean to. You have to know how ashamed I am. You have to know how sorry I feel. I would never have done it if they hadn't told me to. They told me to. They told me that she tricked him. And according to you, this isn't out of the ordinary either, right?
I mean, after he just killed his son, as a detective, we also look for possible motives. And our primary objective at that point was locating Nathan.
All right, detective, let's talk about what you did after interrogating my client. Now, all interrogations are recorded, right?
Yes.
But in this case, we don't have that recording
No.
because you chose not to preserve it.
We usually keep them for about 30 days, and I didn't put in the request. Yes.
Even though you could have.
Yes.
Now, you made the decision not to preserve this recording after conducting the interrogation of Mr. Ray, right?
Yes.
And to be clear, detective, this wasn't a confession for petty theft, was it?
No, it was not. He confessed to murdering his son.
That's right. Mr. Ray had confessed to strangling his son, mentioning the CIA and voices, and you decided not to preserve that recording.
Well, I got the transcript, but I didn't request the audio or the video of it.
All right, detective. Nobody was in the room when you were interrogating Mr. Ray except for you and him, right?
That's correct.
As far as you know, nobody was watching the interrogation while it was going on.
As far as I know, that's correct.
As far as you know, nobody ever watched the recording before it was deleted 30 days later.
As far as I know, yes, that's correct.
Now, detective, you'd agree that the transcript that we talked about a minute ago, that records what was said during the interrogation, right?
Yes.
But it doesn't record things like screaming, does it?
No, a transcript wouldn't contain that information.
The transcript wouldn't record crying either.
No, it wouldn't.
A transcript wouldn't record where someone's looking,
No, it wouldn't.
what their facial expressions are.
That's correct.
Now, so the transcript tells us what Mr. Ray said, but it doesn't tell us how he was behaving.
No, it doesn't.
So the only way we could know how he was behaving without a recording of it is from someone who saw it firsthand, right?
Yeah, I think that's fair to say.
And in this case, that's you.
Yes. Well,
As far as we know, apart from Mr. Ray, you're the only person who could talk about how Mr. Ray was behaving in that interrogation.
yes.
And detective, you've had 2 years to think about what you would tell this jury here today.
Yes.
You've had 2 years of time to think about what you would say knowing my client is pleading the defense of insanity.
I don't focus on insanity. I'm not a doctor. I just came to walk through my investigation of today's case.
But you've had time to think about what you would say when you took the stand today, right?
Just to make sure I give the right facts of why we arrested and charged him with first-degree murder.
So that's a yes to my question. You've thought about what you would say in court today.
Yes.
And detective, you think my client is a piece of shit who'd be better off dead.
Objection, Your Honor.
Withdrawn. No further questions.
All right. Without anything further from the defense, Mr. Castro, do you have any redirect?
Yes, Your Honor. Brief redirect. Detective Booth, your interview with the defendant, that occurred after he killed his son, right?
Yes, it did.
Now, why did you charge the defendant with the murder of his son?
Well, at that time, not only did we have his confession to killing his son, but when we searched the house, it corroborated with what the defendant had said. So did his vehicle, and so did the Google searches.
Now, Detective, did you discover a motive to murder?
Yes, we know that Jessica Ray was having an affair and she'd moved out.
No further questions at this time, Your Honor. May this witness be excused?
Yes, this witness can be excused.
Your Honor, if I may trade spots with my co-counsel who will be directing the next
Sure.
witness.
Sure.
Your Honor, I'm sorry. I'm the timekeeper also. May I have a moment to fix my
Yeah,
timer?
absolutely. Take all the time you need. I'll let Mr. Barrett know whenever you're ready.
What was that, Your Honor?
I'm sorry. I'll let Mr. Green know
I
whenever you're
can't
ready.
hear. Oh, I'm sorry. My sound had gone out. What was that?
Yes, take all the time you need. I'll let Mr. Green know when you're ready.
Thank you, Your Honor. Ready when you are, Your Honor.
All right. State, are you ready to call your next witness?
Yes, Your Honor. At this time, the state calls Dr. McLagrega to the stand.
All right. Dr. LaGreca, you've been sworn in.
Good afternoon, doctor. Can you introduce yourself to the members of the jury?
Hello, my name is Dr. McLagrega.
And what do you do for a living?
So I am a forensic psychiatrist. I have owned and operated my own private practice, and I am currently a program director for a forensic psychiatry program.
How did you become a forensic psychiatrist?
To become a forensic psychiatrist, you have to go through medical school, which I did at UPenn, followed by residency, followed by a fellowship, which I also did at UPenn.
So during your time as a forensic psychiatrist, have you ever testified in any other trials?
I have. So I've been an expert witness at 7 criminal trials, 3 of which involved a defendant who was alleging schizophrenia.
So are you familiar with the facts of this case where the defendant also alleges schizophrenia?
I am.
And were there sufficient facts and evidence in this case for you to form an expert opinion regarding the alleged schizophrenia?
Yes, there were sufficient facts and evidence for me to form a medical opinion regarding this defendant's alleged schizophrenia.
And what methods, skills, or principles did you apply to those facts in coming to your expert opinion?
So I applied my own clinical judgment in combination with my skills and using the standardized method of diagnosing medical health conditions, the DSM.
And with the DSM and those methods and principles, would those be reliable in your field of forensic psychiatrists to come to an expert opinion like that?
Yes, they would be.
And have you formed an expert opinion in this case regarding the defendant's alleged schizophrenia?
I have.
And do you think that opinion, that expert opinion, would help the jurors in deciding this case?
I do.
Your Honor, at this time, the state would move to offer Dr. LaGrega as an expert witness in forensic psychiatry.
Any objection?
No objection, Your Honor.
All right, without objection, this witness has been tendered as an expert in forensic psychiatry. Mr. Green, you can proceed.
Why are you here today, doctor?
I am here today because the defendant killed his son by asphyxiation on October 17th, 2018, and he is now alleging to have suffered from schizophrenia at that time.
And real quick, can you tell us what asphyxiation means?
Colloquially, it could be referred to as strangling.
So what happened on October 17, 2018?
So per the report, the defendant became enraged with his son after his son reportedly spilled produce on his work laptop, at which point the defendant forced his son into his bedroom where he forced him to do physical exercise.
And what did the defendant do after he forced Nathan to do these exercises?
So notably, the defendant went to his own bedroom, grabbed a belt, and sat on his bed to calm down before going to Nathan's room where he eventually strangled his son.
So hypothetically speaking, doctor, if a person were to go into the room or stop and reflect on their actions before committing an act like murder, what in your expert opinion would that lead you to conclude?
Objection, Your Honor. Improper opinion, or this calls for an improper opinion under 704.
All right, let's move outside the presence of the jury. And Mr. Barrett, let me hear your argument.
Yes, Your Honor. Although Pasquarello allows this expert to talk about a disease and how that affects mental condition. This question calls for going further than that and asking whether or not a defendant knew what they were doing in that moment, knew right from wrong. And under 704, this is not allowed.
If I may respond, Your Honor.
Of course.
This does not go to the ultimate issue in this case, which would be the defendant's mental state at the time he murdered his child. This is a hypothetical. And further, as the state, we have the burden of proving that the defendant murdered Nathan Ray with premeditation and that he intended to. This goes to his intent before he killed and shows that he had the intent to kill Nathan.
May be heard, Your Honor.
1 second. Mr. Green, tell me again the question that you asked that drew the objection, the specific question that.
I asked this witness, hypothetically speaking, if someone were to stop and reflect on their actions before committing an act like murder, what, if anything, would it lead you to conclude in your expert opinion?
Okay, Mr. Barrett.
Yes, Your Honor. Saying hypothetically speaking before explicitly describing the facts of this case isn't a way to go around the rules of 704. This is still asking for the expert to give an opinion on whether or not the defendant knew right from wrong in that moment. This goes beyond the expertise. It's not talking about any disease that the expert can testify to.
Well, I think that we have established that that we do have an expert in forensic psychiatry here, right?
Yes, sir.
I hear your objection, and it's close, but I'm going to overrule the objection.
Yes, sir. Your Honor.
So,
Back inside the presence of the jury, Mr. Green, you can proceed.
So, Dr. LaGrega, I'm going to ask that question again. So, hypothetically speaking, if someone were to stop and reflect on their actions before committing an act like murder, what, if anything, would it lead you to conclude in your expert opinion?
So in my opinion, this would lead me to conclude that the person had enough time to come up with the idea to kill, decided on committing the act to kill, and did in fact go through with that action.
And what is your expert opinion regarding the defendant's alleged schizophrenia at the time he strangled his son?
Objection, Your Honor. This question calls for an improper conclusion under 702. May I be heard?
Yes, you may. Outside the presence of the jury. Go ahead, Mr. Barrett.
Your Honor, 702 prong B states that an expert needs to rely on sufficient facts or data to come to a conclusion. In this case, there are not sufficient facts and data. Now, although the expert stated during her direct examination she relied on sufficient facts and data, it's your role as a gatekeeper to determine if this is true. In this case, it's not. This expert did not interview Mr. Ray, did not ever see Mr. Ray's behavior in any context, video or otherwise, and didn't interview anyone who knew Mr. Ray. This is not sufficient facts or data to go into a person's mental state and make a diagnosis.
All right, Mr. Green, what's your response?
Your Honor, as this witness has already been tendered by this court as an expert witness in forensic psychiatry, this would have been something to bring up when I did tender this witness. However, there were sufficient facts and evidence in this case, which this witness has testified to being true, and therefore she should be able to comment on the alleged schizophrenia of the defendant, which is her role in this trial.
Maybe heard, Your Honor.
Mr. Barrett's last word.
Yes. Your Honor, we agree that Dr. LaGreca is a skilled forensic psychiatrist and thus is an expert in forensic psychiatry. However, 702, that's only one prong. 702 needs the expert to be relying on sufficient facts or data. In this case, it's simply not there. The expert did not ask any follow-up questions to anyone who knew about this case, was not able to look at the behavior of anyone who was being interviewed, was not able to ask any questions relating to her conclusion of malingering. Instead, she just read some documents. This is not enough to be called sufficient facts or data. So,
I understand your argument, and I agree. I am the gatekeeper, but Dr. LaGreca did testify that she did have sufficient facts and data. And I think this is a question of weight, not admissibility. And I hope that you take up all of these issues with Dr. LaGreca on cross-examination. So the objection is noted but overruled.
yes, Your Honor.
So what is your expert opinion regarding the defendant's alleged schizophrenia at the time he strangled his 6-year-old son?
It is my opinion that on October 17th, 2018, the defendant did not suffer from any severe mental illness, including schizophrenia.
And just so the jury can understand how you reached that expert opinion, can you tell us what schizophrenia is?
Sure. So schizophrenia, as qualified by the DSM, would be the presentation of a positive and negative symptom for over a month duration.
And were those positive or negative symptoms exhibited by the defendant for longer than a month in this case?
No, they were not.
Well, was the defendant ever diagnosed with schizophrenia by any other doctors?
No, he was not.
Well, in your review of the medical records, who was the first doctor the defendant visited?
That would be Dr. Riley.
Who is Dr. Riley?
So Dr. Riley is also a forensic psychiatrist. He's been hired by the defense to testify on this trial. But in 2010, he was employed by the Army and performed a full psychiatric exam on the defendant, and this lasted a total of 3 days.
So while Dr. Riley and the defendant are employed by the Army for this 2010 evaluation, what were the results of that evaluation?
So after monitoring the defendant for an appropriate 3-day period, Dr. Riley concluded that the defendant was not a threat to himself or others, and she then released him.
So was this the last time that Dr. Riley and the defendant would have a medical appointment together?
Up until right before this trial, yes.
And what caused that second medical evaluation performed by Dr. Riley on the defendant?
Dr. Riley was hired by the defense after the defendant had been accused of murder.
And was Dr. Riley hired by the defense during this medical evaluation in 2019?
Yes, he was.
And what were the results of that medical evaluation performed in 2019 by Dr. Riley?
So on this clinical interview, the defendant reported new onset symptoms that weren't found anywhere else in the record, which caused Dr. Riley to diagnose him with schizophrenia.
Dr. LaGrega, was the defendant aware he had been charged with murder at the time of this medical evaluation?
Yes, he would have been.
And so what, if anything, did that lead you to conclude in your expert opinion?
With the knowledge or intention of perceived punishment, the temporal association of the presentation of the symptoms with the perception of punishment led me to believe that this is more an instance of malingering.
Can you tell us what malingering means?
Sure. So malingering is when a person presents with symptoms in order for some perceived benefit.
So was there any other evidence in your view of this case which led you to the conclusion this defendant is malingering?
Yes, I could reference the Google searches.
So what did those Google searches say?
So the first Google search was how to get rid of a body. The second one was, does bleach destroy a corpse? And the last was countries that don't expedite for murder.
So how to get rid of a body, will bleach destroy a corpse, in which countries don't extradite for murder? Why are those evidence of malingering in your expert opinion?
So this would be evidence that the defendant is trying to conceal a crime, which in my opinion would point more towards malingering.
And was there any other evidence of malingering in this case?
I would cite the interaction with Officer Wentz at the sobriety checkpoint.
So why would you cite that interaction with Officer Wentz as being evidence of malingering?
So per Officer Wentz's testimony, at the beginning of this interaction, he was coherent and talking to him perfectly fine. He did lie about having his ID, which Officer Wentz was able to spot in the car. And it was only after he was identified that he started presenting with these kind of odd Hollywood symptoms.
And after the defendant was identified as being Timothy Ray, was there anything found in his car?
Yes. So Officer Wentz found the trash bags and bleach in a shovel in his car.
Was the defendant exhibiting odd behavior before Officer Wentz had identified him or discovered those items in his car?
No, he was not.
So, what is your expert opinion regarding the defendant's alleged schizophrenia on October 17, 2018?
So based on this, based on the facts and evidence, my expert opinion would be that the defendant was malingering and did not suffer from schizophrenia at the time that he strangled his son.
No further questions for this witness at this time, Your Honor.
All right, defense, are you ready for your cross?
Yes, Your Honor. May I proceed?
You may.
Good afternoon, Dr. LaGreca.
Good afternoon.
I want to start by talking about whether you had enough information to form your conclusions. Now, you concluded that Mr. Ray is malingering, right?
I did.
In other words, you concluded Mr. Ray was faking symptoms of schizophrenia. That's true?
Yes.
Now, Dr. LaGreca, it's true that before his son's death, Mr. Ray met with 4 medical professionals that you're aware of, or had visits with 4 medical professionals that you're aware of.
He had 4 visits with 2 medical professionals.
Right, and you weren't at any of these visits.
No, I was not.
After his son's death, Mr. Ray spoke with multiple police officers.
Yes, he did.
You weren't at the traffic stop with Officer Wentz.
No, I wouldn't have been.
You weren't in the interrogation room with Detective Booth.
Like Dr. Riley, I was not.
Instead, you read about these interactions, right?
Yes, I did.
But Dr. LaGreca, it's true, there's a difference between a written transcript and being in the room.
Yes, there would be.
Well, a written transcript doesn't show body language, does it?
If it was written by a psychiatrist, sometimes it will describe body language, but typically no.
The written transcripts you reviewed did not show body language.
Yeah, sure.
The written transcripts you reviewed didn't show facial expression.
Not to my knowledge, they did.
The written transcripts you reviewed didn't show tone of voice.
Objection, Your Honor.
All right.
Uh,
Outside the presence of the jury, but what's your objection?
We object that under 403 at this time, these responses are becoming needlessly cumulative, and there's no probative value of getting these same responses out from this witness as was gotten out with the Detective Booth. Therefore, there is no probative value, and it's highly outweighed by the needlessly cumulative evidence that the defense is trying to put forth.
May be heard.
Yes, Mr. Barrett.
Your Honor, it's more important to ask these questions to this expert. This expert made conclusions about state of mind without seeing Mr. Ray. This goes towards that and thus is relevant and not needlessly cumulative.
Agreed. Objection's overruled.
Yes, Your Honor.
May I continue?
You may. Back inside the presence of the jury.
So, Dr. LaGreca, to be sure, the written transcripts you reviewed didn't show tone of voice.
No, they did not.
You concluded that Mr. Ray was malingering without ever treating him.
You typically, I wasn't his psychiatrist, so I wouldn't be able to prescribe treatment, and malingering, to my knowledge, does not have like a medication that I would prescribe.
So, Dr. LaGreca, bringing back to my question, you concluded Mr. Ray was malingering without ever treating him. That's right.
Yeah, I didn't treat him.
Without ever seeing him.
Yes.
Without ever being in the same room.
I don't believe I was allowed to interview him, so yes.
So that's a yes to my question. You were never in the same room with Mr. Ray, before or after his son's death.
No, I was not.
Now, Dr. Greca, this is the eighth time you've been retained in a criminal case, right?
Yes.
But it hasn't been a 4-4 split.
No.
6 out of 7 previous times you've been retained by the prosecution.
Yes.
And after today, that's 7 out of 8.
Yes.
Let's talk a bit more about your conclusions, Doctor. You believe Miss Ray was not suffering from schizophrenia. That's true?
That is true.
But you'd agree that a person's more likely to suffer from schizophrenia if they show several signs.
Sure.
That's a yes?
I'm not sure what the signs are.
Several signs associated with schizophrenia, exacerbating factors and signs the DSM states.
Okay, yeah, then yes.
Let's talk about those signs, Doctor. Your Honor, permission to display a demonstrative for the jury?
Yes.
Now, Dr. LaGreca, it's true that anxiety disorder can worsen and lead to a more severe mental illness,
Yes, that is possible.
like schizophrenia.
Very rare cases, yes.
So that's a yes, it can lead to schizophrenia?
It would be a contributing factor towards schizophrenia. I don't think anxiety on its own would lead to schizophrenia. But
Objection, Your Honor.
Mr. Green, move outside the presence of the jury. What's your objection?
By having this demonstrative in front of the jury, counsel is testifying to answers that this witness has not yet agreed to. This is not her testimony being shown to the jurors.
Maybe heard, Your Honor.
You may.
Your Honor, before we put up anything, the expert explained that it was prior anxiety diagnosis is an exacerbating factor. She was talking about this when she explained whether or not it would lead to. She said it would be an exacerbating contributing factor.
Yeah, Mr. Green, as long as I hear, at least some type of, as this is a demonstrative, as long as I hear some type of testimony that goes along with what is being put on the demonstrative, I'm going to allow them to do that. But and I did hear that on this prior anxiety disorder diagnosis. So I'm going to overrule the objection, but feel free to re-raise that if the defense goes in and starts putting things on this demonstrative that have not been testified to. Okay.
Yes, Your Honor.
All right.
May I
You can
continue?
proceed. We're back inside the presence of the jury.
Dr. LaGreca, childhood trauma can make a person more likely to develop a severe mental illness like schizophrenia as well.
it is a known contributing factor, yes.
Mr. Ray suffered from childhood trauma.
Yes, unfortunately.
Mr. Ray was diagnosed with anxiety disorder before October 2018.
Yes, he was.
Now, it's also true that a family history of severe mental illness makes a person more likely to develop a severe mental illness, like schizophrenia.
Yes, that would be true.
Mr. Ray's mother suffered from a severe mental illness.
One that we are not aware of what it was, but yes, she did.
You would agree that she was institutionalized.
Yes, I did see that in the report.
Now, I want to talk to you a bit about the DSM-5. You'd agree that's a reliable authority on diagnosing schizophrenia, right?
Yes, any psychiatrist would.
The DSM-5 states that delusions are a sign of schizophrenia.
Yes.
Now, Mr. Ray visited Dr. DiGiuseppe in 2017 or 18, right?
Yes.
He told the doctor he feared his wife was having an affair.
A fear that turned out to be valid, yes.
So, Dr. LaGreca, bring you back to my question, that's a yes. He told the doctor in that meeting he feared his wife was having an affair.
Objection, Your Honor.
All right, let's move outside the presence of the jury. What's your objection?
This is mischaracterizing this evidence. As this witness has just said, these weren't delusions because they turned out to be true, and therefore this shouldn't be evidence of delusions. You can't be a delusion if it's in fact true.
Maybe heard, Your Honor.
You may.
Your Honor, we're using this as evidence of delusions for the entire visit itself. Well, if I may make an offer of proof.
Yeah, we'll stay outside the presence of the jury. You make an offer of proof.
So the delusions don't just refer to Mr. Ray fearing he had an affair, his wife had an affair back in 2016 or 2017, which wasn't the time established the affair actually happened. In addition to this, during this visit, Mr. Ray accused the doctor of talking behind his back to his wife, and then listening in on his phone calls. Those three together are examples of delusions.
Your Honor,
Mr. Green?
if I may respond, while those three might be examples of delusions, the only one that this witness was questioned by so far was about something that is not a delusion because it was in fact true, which is what this witness was stating.
May be heard, Your Honor.
Your last word, Mr. Barrett.
Yes, Your Honor. Your Honor, we put up delusions after the witness answered that it is a sign of schizophrenia. We're then asking independently about this incident, just showing the jury that this could very well be a delusion, but we don't need the expert in this case to agree with our side of the case. It's the expert for the prosecution.
I agree. That was where I was going to go. I think that the demonstrative that is on the board is that on the screen at least is talking about signs and exacerbating factors of schizophrenia. I think that's what went on there, and I think your questions were still in line with delusions in general and talking about this specific instance. So I'm going to overrule the objection, but it is noted, and we're going to go back inside the presence of the jury. Mr. Barrett, you can continue.
Yes, Your Honor. Dr. LaGreca, he then accused the doctor of talking to his wife behind his back.
Yes, a paranoid episode, yes.
He accused the doctor of listening in on his phone calls.
Yes, he did.
Dr. LaGreca, this visit happened before October 2018.
Yes, it did.
Now, the DSM-5 states that hallucinations are a sign of schizophrenia, right?
Yes.
Mr. Ray said he started hearing voices when he was a child.
I did hear that report. Yes.
He said he started hearing them again in 2015.
A report given after he was accused of murder, yes.
So that's a yes to my question. He said he started hearing them again in 2015.
Yes.
And in 2018, he said they came back.
Yes.
And Dr. LaGreca, during his interrogation, Mr. Ray said multiple times, "They told me she tricked him," right?
Yes.
Dr. LaGreca, you never saw the video footage of this interrogation.
No, I did not.
Thank you, Doctor. Nothing further, Your Honor.
All right. Any other redirect?
Yes, Your Honor, brief.
Okay.
Dr. LaGreca, on cross-examination, you discussed symptoms, but were these all present at the same time for over a month in the defendant's life?
To my knowledge, they were not. You would need these symptoms present for a month duration in order to accurately classify schizophrenia.
And why weren't you allowed to interview the defendant in this case?
I believe I was prevented from doing so by the defense.
And why do you believe the defendant is malingering in this case?
So based on my review of the record, any instance of a hallucination or any reports that Timothy made were made after he had been accused of murder and would have been for some perceived benefit at that point.
Thank you, Dr. LaGreca. Your Honor, may this witness be excused at this time?
Your Honor, I believe you might be on mute.
I'm sorry, I was on mute. Yes, this witness is excused, and we will go into any mid-trial motions that the state might have, or the defense might have.
If we may have one moment to switch rooms, Your Honor.
Yeah, absolutely.
Thank you.
All right. Any motions we need to take up with the court?
Your Honor, because we're pleading an affirmative defense today, we are not bringing any motions for dismissal under Rule 29.
Okay. Anything from the state for mid-trial motions?
No, Your Honor. The state rests its case in chief.
All right. We will now move. We're going to take a quick, I'm going to give you all a couple of minutes just for a quick break. I know this is long, so why don't we come back at, what, is 5 minutes okay with you guys? Go to 2:47 or 1:47, wherever you're at, 47, wherever you're at.
Yes, Your Honor. But before we do, could we ask for a quick time check?
Yes, absolutely. Let's go ahead and get time checks figured out.
Right now, I have the state with 23 minutes and 35 seconds, and the
All right,
defense.
hold on 1 second. Mr. Wentz, which team are you with?
I am with the defense team, Your Honor.
All right, so this is the defense time, and you had.
Oh,
the
I'm
state.
sorry.
Yeah, I just want to make sure who's keeping what, because I know both of y'all are keeping time. On the defense side, you had the state at what?
I have the state currently with 23 minutes and 35 seconds remaining.
Remaining. 23 minutes, 35. All right, and for the defense?
Right now, I have the defense with 30 minutes and 23 seconds remaining.
All right, let me hear from the other timekeeper for the state.
Your Honor, while I was on the stand, one of my teammates was taking time, so I just need to go collect that time really quickly.
Okay, well, why don't we do this? While you go and do that, we'll take our break. And now since we've kind of talked through a little bit, we're just going to come back at 50. So when we come back at 50, we'll go ahead and get started with the defense case, and we'll get your time check, okay?
Yes, Your Honor.
All right. All right, I think we have all the advocates back. So I know Mr. Cassib and Mr. Green are sharing a room. So I just want to be sure our jurors are back. If you could give me a quick go ahead that you're back and we'll get started.
Yep.
Back.
Okay. One more. Mr. Waldenberger, are you back?
I'm back. We're waiting on
Okay.
Pat. I'll give him a call.
I'm here.
Okay. All right. All right. Now we have everybody back. And we will, if you could go ahead and stop your videos, we'll get back to the defense case in chief. And defense, when you're ready.
Yes, Your Honor. The defense calls Dr.
Oh,
Riley
wait, I'm
to the
sorry.
stand.
I'm sorry. 1 second. I meant to get the time from the state.
Oh, that's right.
I forgot to do that.
Your Honor, we had an issue with one of our timers at the time, so we are fine with continuing with defense timekeeper.
All right, so the state's stipulating to the defense's time. So I have the state with 23 minutes and 35 seconds remaining, and the defense with 30 minutes and 23 seconds remaining. Any objections? We're all good there?
No, Your Honor, no objections. May you just repeat that one more time, please, so I can write it down.
State with 23 minutes and 35 seconds remaining, and the defense with 30 minutes and 23 seconds remaining.
Got it, Your Honor.
All right, and we can go ahead and start with the defense case.
Yes, Your Honor. The defense calls Dr. Riley to the stand. Good afternoon.
Afternoon.
Please introduce yourself to the jury.
I'm Dr. Shane Riley or Major Shane Riley, depending upon the situation.
What do you do for a living?
I'm a forensic psychiatrist.
And how are you involved in today's case?
I was asked to determine if Timothy Ray was suffering from a schizophrenic episode on or around October 17th, 2018.
Before we get to your conclusions, I want the jury to get a sense of your qualifications. Where'd you go to school?
Got my bachelor's from Notre Dame. I attended the Uniformed Services University School of Medicine, and then subsequently did both my general psychiatry residency and forensic psychiatry fellowship at Walter Reed National Military Medical Center.
And doctor, how long have you been practicing?
Since 2002.
Are you published in your field?
Yes, I am. 15 papers.
Are any of those 15 papers specifically related to schizophrenia?
2 of them are.
Apart from your work in today's case, do you have any experience determining if someone has schizophrenia?
Yes, that's a standard part of general psychiatry training.
And finally, doctor, just for full disclosure, are you being compensated for your time?
Yes, I am.
The defense offers Dr. Riley as an expert in forensic psychiatry and schizophrenia.
Any objection?
Your Honor, may I have permission to take this witness on a brief voir dire?
Yes, you may. Let's move outside the presence of the jury, though.
Dr. Riley, you've testified in cases before,
Yes, I have.
and you've testified in cases dealing with schizophrenia. Is that correct?
I'm a little bit I at the moment don't recall every case I've testified in. It's been several.
But you've testified in cases that deal with criminal charges, right?
Yes, I have.
And in all of the cases you've testified in, you've only testified on behalf of the prosecution once?
I don't specifically recall.
You don't specifically recall being hired only once by the prosecution?
I do not recall that. I come in, I make my analysis, my assessment, make my conclusions based on the person who I see. And so it's not really material to me what side it's for.
Okay, Your Honor, we have no objection to this witness being offered as an expert in forensic psychiatry.
Okay, so are you withdrawing your objection? I'm a little confused.
I had no objection. I just wanted to take this witness on brief voir dire.
Okay. All right, without objection, we'll tender this expert. We'll tender Dr. Riley as an expert in forensic psychiatry, and we'll move back inside the presence of the jury. Mr. Hitchcock, you can continue.
Yes, Your Honor. Let's talk about your work specifically for today's case. Was Timothy Ray a patient of yours?
He was once in 2010 at Walter Reed National Medical Center.
When did you conduct clinical interviews of Mr. Ray?
At that same time in 2010, and then also in 2019.
Now, apart from these clinical interviews, what materials did you rely on for your work today?
All of the materials in the joint exhibit, as well as the 3 additional interviews I conducted with his father, Mr. Ray's father, his ex-wife, and his boss.
What methods did you use to analyze these materials?
I compared the materials that I saw in front of me and my interviews to the symptoms, signs and symptoms of schizophrenia in the DSM-5 and that definition.
Now, is comparing the symptoms exhibited by an individual to those listed in the DSM a standard method in psychiatry?
Yes, absolutely.
Did you reliably apply that method to the facts and data of this case?
Yes, I did.
And finally, doctor, were the materials that you reviewed sufficient to form any conclusions to a reasonable degree of medical certainty?
They were.
Doctor, if you could, tell the jury, what were your conclusions?
My conclusions are that Timothy Ray was suffering from schizophrenia, and further that he was suffering from schizophrenia around the time of October 17th, 2018.
Let's break those down for the jury, starting with your first conclusion. First, could you tell the jury what schizophrenia is?
Schizophrenia is a psychiatric disorder characterized by psychosis, among other things.
Now, is every case of schizophrenia the same?
No, there's a spectrum of disease from very mild to very severe.
Do people suffering from schizophrenia always know the difference between right and wrong?
Not always. It would depend on the severity of their symptoms at any given time.
Now, a minute ago, you said that you used the DSM to diagnose Mr. Ray with schizophrenia. How'd you do that?
So I used the 5 criteria listed in the DSM. In order to make a diagnosis of schizophrenia, the patient must exhibit at least 2 of those symptoms for a month or longer.
How many of those symptoms did you conclude Mr. Ray was exhibiting?
I concluded he was exhibiting 3: hallucinations, delusions, and negative symptoms.
Let's break those down for the jury. I understand that you've prepared a chart to assist with your testimony today, correct?
Correct.
Your Honor, permission to display Dr. Riley's chart?
Yes.
Let's start with the first symptom we see here, hallucinations. Could you tell the jury what is a hallucination?
Hallucination is a perception of something that isn't there, isn't perceivable to other people.
Why'd you conclude that Mr. Ray was experiencing hallucinations?
Well, because he talked about both seeing shapes and hearing voices.
How long had Mr. Ray been experiencing hallucinations?
Well, he was referred to the Walter Reed National Medical Center in 2010 for visual hallucinations, so potentially as far back as that, and auditory hallucinations since he was about 10 years old.
All right, let's turn to your second conclusion now. What are delusions?
Delusions are fixed false beliefs that a person holds, typically that are improbable.
Why did you conclude that Mr. Ray was experiencing delusions?
Well, because he multiple times accused many people of being working for the CIA, saying they were following him, suspecting that he was a terrorist, and also that his wife and son would cut him up with a knife and leave him.
How long had Mr. Ray been exhibiting delusions?
Since 2015.
Now let's turn to your last symptom, negative symptoms. What do you mean by that?
Negative symptoms is, in a way, sort of the absence of normal things, the ability to regulate one's emotions, care for oneself, or interact normally in a social situation.
Why did you conclude that Mr. Ray was exhibiting negative symptoms?
Well, he had had some changes in his sleep pattern. Multiple people described his lack of adequate personal grooming. Seemed he had difficulty with social connections, sort of on a regular basis, and he did not regulate his emotions very well at all throughout most of this.
How long had he been showing negative symptoms?
Throughout his marriage, but particularly in late 2017, early 2018.
All right, doctor, let's turn to your second conclusion. Now, without getting into Mr. Ray's specific state of mind or whether he knew right from wrong, were you able to determine if he was experiencing a schizophrenic episode that day?
Yes, I was.
What was your conclusion?
My conclusion was that indeed he was suffering from an episode on that day.
How do you know that?
Well, there was evidence that he was experiencing all three of the symptoms that we've already talked about, consistent with schizophrenia.
All right, let's go one by one again. What hallucinations was he experiencing?
He was experiencing voices telling him that his wife was trying to sabotage him, telling him to kill his son, and so forth.
What about delusions?
Yes. So he did state to the officer that he believed his son was possessed with evil and he needed to cleanse him with physical punishment. And he also made many accusations about the officers being CIA.
And negative symptoms?
Yes. So as I discussed, his generally unkempt appearance, body odor, and sort of his emotional explosions throughout those interviews.
All right, well, I'm no expert, doctor, but couldn't Mr. Ray have just been faking these symptoms?
Certainly he could have. Yes.
Well, how confident are you that Mr. Ray is not, in fact, malingering?
Very. I've seen this plenty of times, and I concluded to a reasonable degree of scientific certainty that the defendant was not malingering.
Thank you, doctor. Your Honor, we have no further questions at this time.
All right, are we ready for cross?
Yes, Your Honor. So, Dr. Riley, When you saw the defendant for the first time, that was in 2010, is that correct?
That's correct.
And in 2010, this interaction with the defendant, that lasted for 72 hours?
You know, that's not entirely clear to me from the chart. I appear to have done the admission. I interviewed him initially, and I documented that my plan was that he would likely be there for 3 days. But I don't recall having seen anything further about seeing him in the subsequent days, just that the plan was to continue to monitor. And, you know, that happens a lot in medicine, that the person who admits the patient isn't necessarily the one who follows along with them for the entire course of their stay. It can change several times within an admission.
Okay, doctor. So you're not sure if the defendant was there for 72 hours under observation at Walter Reed Medical Hospital in 2010? Are you sure or not sure?
I'm not sure.
But you made a diagnosis of the defendant, didn't you, after 2010?
Yes, after my evaluation of him.
But you don't know how long he stayed for you to make this diagnosis in 2010?
Sometimes people make diagnoses after one encounter with a patient if it's clear what's going on at that time.
Go ahead, doctor.
No, that's fine.
Well, so you thought it was clear in 2010 that the defendant only had a general anxiety disorder. Is that correct?
When I evaluated him at that time, yes, I did think that was clear.
Now, in 2019, you saw the defendant again. Is that correct?
That is correct.
And in 2019, you had a 3-hour interview with the defendant. Is that correct?
If that is what I documented in my report, then that is correct.
So, doctor, at the end of this 3-hour interview, you gave an opinion, and that opinion was the defendant suffered from severe schizophrenia. Is that correct?
Yes.
So, doctor, between your 2010 and your 2019 diagnosis, the defendant killed his son, right?
Yes.
And between your 2010 and your 2019 diagnosis, the defendant was charged with the murder of his son, right?
Yes.
Between your 2010 and your 2019 diagnosis, you were paid by the defendant's attorney. Is that correct?
Yes.
So, doctor, let's talk about some of the stuff that the defendant told you in that 2019 interview, all right? So, he reported to you that he was hearing things, and he even asked you about if you were in the CIA.
Mm-hmm.
And you had mentioned that other people had also heard the defendant ask if they were in the CIA, right?
Yes.
I believe it was police officers you had mentioned on direct.
Yes, he did ask both of the officers whether they were in the CIA.
And he came into contact with those police officers after he had killed his son, right?
Yes.
So these delusions or hallucinations, they occurred after he had killed his son, right?
Yes, the CIA ones, certainly.
So I'd like to talk to you about malingering. Now, you gave an opinion that the defendant was not malingering, but I want to clarify for the jury what malingering is. So, doctor, can we agree that malingering is faking symptoms of a mental illness in order to receive a benefit? Is that a fair way to define malingering?
I would request that you drop the mental illness component. It can really be symptoms of any illness.
Oh, okay. Symptoms of any illness in order to receive some benefit. Is that fair? We can agree that that is malingering?
Yes.
Sure. And some benefit that someone might receive would be a legal defense. Maybe? Can I get a yes or no?
Yes.
So someone who's malingering, they would be doing so to create a legal defense in order to receive a benefit like avoiding jail time, right?
Yes.
So, doctor, is being charged with the murder of your son a motive to malinger? Sorry, was I not clear in my question?
Yeah, if we could rephrase it, that would be lovely.
Well, doctor, I'll just ask it again. Is being charged with the murder, is that a motive to malinger?
It could be.
It could be. Okay, that's great. That's great, doctor. So I'd like to talk a little bit about how you came to your conclusion. Now you had interviews with other people that the defendant was in close contact with. Is that correct?
That is.
And, you spoke with the defendant's wife. Is that correct?
Yes, I did.
You spoke with the defendant's boss. Is that correct?
Yes.
You spoke with the defendant's father. Is that correct?
Yes.
But none of these people reported to you that the defendant had any hallucinations or delusions, right? Doctor, if I could just ask you what you're looking at. You seem to be, your eyes seem to be glancing off screen. I'm just wondering if you have anything there that is aiding you today.
Objection, Your Honor. Badgering the witness. May we be heard outside the presence of the jury, Your Honor? Your Honor, you're on mute.
Sorry. Yes, we'll move outside the presence of the jury, and let me handle this. Dr. Riley, are you referencing anything in the course of your testimony?
I have some notes.
Okay, you do have some notes?
Yes, sir.
Okay. Put the notes away and let's go off of what you know and your basis of your knowledge and stay in the course of this case, okay?
Okay.
So no need of objection, but let's go back inside the presence of the jury. Mr. Kassob, you can continue.
Sure. So based on these interviews with the defendant's wife, his boss, and his father, none of them reported to you that he was suffering any delusions or hallucinations. Is that correct?
Not that I recall.
And people like his wife and his boss of 7 years, wouldn't they be people who would able to tell you if he was suffering from hallucinations or delusions?
Objection, speculation.
Your Honor, if I might respond. You're on mute again, Your Honor.
Yeah, you can respond. You can respond.
Sure. Well, this witness has already testified that the police officers and herself were able to determine that the defendant experienced delusions and hallucinations in front of them. I'm only asking if those people who have close contact with the defendant would be able to experience those delusions and hallucinations as well.
Your Honor, may I respond?
You can.
Your Honor, this is assuming that these people were told that these symptoms were reported. Regardless of whether or not the defendant was reporting these symptoms to other people or not, has no bearing on whether or not he was experiencing them. And the state is trying to make it seem like just because these people hadn't heard about them, the only way they could possibly know that he was experiencing delusions or hallucinations would be stepping inside his own mind. That's speculation and it's inadmissible.
Your Honor, if I may respond.
Yeah, last word, Mr. Kassob. Make it brief.
The defense has already opened this door wide open with their demonstrative concerning delusions and hallucinations. We're only asking this witness who had an interview with these other witnesses if they would be able to have the observations of these delusions or hallucinations.
All right. I understand the objection, but I do think you got into a little bit on the direct with your expert as well. So I'm going to overrule the objection. But Mr. Gaspar, I'll warn you that we're starting to flirt the line of speculation. So let's get through this and move on. Okay.
Okay, so I'll just ask the question.
We're back inside the presence of the jury.
Doctor, a wife and a boss of 7 years, wouldn't those people be most likely to see a hallucination or delusion from somebody who has severe schizophrenia?
If they were experiencing them in the presence of those people, sure.
No further questions at this time.
All right. Any redirect?
No redirect, Your Honor.
Without redirect, this witness can be excused. Does the defense have any other witnesses?
Yes, Your Honor. The defense calls Officer Peyton Wentz.
All right. Mr. Wentz, you have been sworn in. And Mr. Barrett, when you're ready.
Your Honor, may I have just a moment to compile the times from the previous examination?
Yeah, yes, absolutely.
Thank you very much.
Just let me know when you're done.
I'm all set, Your Honor.
All right. Mr. Barrett.
Good afternoon, Mr. Wentz.
Afternoon.
Could you please introduce yourself to the jury?
Of course. My name is Peyton Wentz.
What do you do for a living?
Well, I'm a police officer right here in Skelton County.
What training did you receive to become a police officer?
I went through the typical police academy training. We learned about the laws of West Carolina, criminal investigative procedures, and then I also participated in the crisis intervention team. It's kind of a specialized training program for people with mental health issues.
Let's talk about how you're involved in today's case. Do you know Timothy Ray?
Yes, I do.
How so?
Well, I was the one who stopped Mr. Ray. This was at a DUI checkpoint on Route 22 on October 18th. This was the stop that ultimately led to his arrest.
Let's take a step back. What were you doing right before you stopped Mr. Ray?
Well, before Mr. Ray arrived, it was a routine night shift. My partner and I were sending people through the checkpoint like usual. We actually hadn't even made any arrests at that point.
When'd you stop Mr. Ray?
That would have been about 9 p.m.
How was Mr. Ray looking when you first stopped him?
Well, his hair was all messed up. His eyes were glassy. I saw stains on his clothes, and I could smell his overwhelming body odor. It kind of looked like he'd been in the car for days.
So what'd you do?
Well, it was a traffic stop, so I asked Mr. Ray for his license and his registration.
How did Mr. Ray react to this?
Well, he got all antsy, and he asked me why I needed them. When I told him it was just routine, he tried telling me he had forgotten his wallet at home, and that he didn't have his registration either.
What happened next?
Well, it was clear he had no idea what he was talking about. His wallet was sitting right there in the open, right on the center console. So I pointed this out to him. Well, he finally ended up taking out his license and registration and giving me both.
What did you do after you received the license and registration?
I started walking back to my squad car to run the information on his plates. On my way there, I just happened to glance through Mr. Ray's front and back windows of his car.
Let's focus in on what you saw, Officer Wentz. What you see through the front window?
There was trash all over the front seat, passenger seat to be specific.
And what about the back?
Well, it was also a mess, but for a different reason.
Officer Wentz, I'd like you to take a look at Exhibit 22 in your electric binder. Do you recognize this?
Yeah, that looks like a photo of the backseat of the defendant's car.
Is it a fair and accurate depiction of what you saw when you looked through his back window?
Sure looks like it.
Your Honor, the defense moves Exhibit 22 into evidence.
Any objection?
We've not seen this published, I guess, yet to this witness, if we may see it.
Certainly.
Yes, Your Honor. Yeah, yes, Your Honor. If we may constructively outside the presence of the jury, displayed on the
course.
screen.
Of course.
Yes, no objections at this time, Your Honor.
All right, without objection, it's admitted. And
May we
back inside the
publish?
Yes, you may now publish.
Thank you, Your Honor. Officer Wentz, can you tell the jury what you saw?
Sure. So you can see here there's a dirty shovel, a couple of bleach containers sitting on the back seat, and several large trash bags. They were all just sitting out there in the open, just like the wallet was.
Thank you, Mr. Hitchcock. You can take that down. I want to go back to the traffic stop. What'd you do after looking through the back window?
Well, I had my partner run the information, and I went back to talk to Mr. Ray.
How'd Mr. Ray react when you got back?
He started yelling, "Are you with the CIA?" I said no, obviously, but he kept yelling that he knew the CIA had been watching him because they thought he was a terrorist. He said he could hear the sirens of the CIA.
So what'd you do after hearing this?
I told him this is just a routine traffic stop, but because he was yelling and getting belligerent, I asked him to step out of the vehicle.
Did he comply?
Eventually, but he kept asking me for my CIA credentials. I told him again, I was just a police officer. I even showed him my badge and everything. But when eventually he got out, but then he changed.
Officer Wentz, what do you mean changed?
Well, before he was frantic, but after he got out of the vehicle, he started moving really slowly, had a complete blank stare, and wouldn't make eye contact with me at all. Then he started talking in this monotone voice, not to me, but just to himself, I guess.
Excuse me, Your Honor. I experienced just a bit of technical difficulties. If you mind, could we take a quick sidebar so I can just get the...
Yeah, of course. Of course. It's inevitable with this kind of setting, so.
Just one moment. Can you hear me?
I can hear you.
And I can hear you now. Great. Thank you so much, Your Honor. And I kind of cut out at the end of Officer Wentz's question. So if you don't mind, could I just have him repeat the last thing he said?
Yeah, absolutely.
Sure.
Mr. Barrett, why don't you just re-ask your question?
Yes, of course. So what happened next? What happened after? Excuse me, Your Honor. It kind of cut out for a while. I'm not quite sure where he was in his answer. I apologize.
That's okay. Do you remember what your question was? That where he cut out for you?
I think I asked, what'd you do after he started screaming about the CIA, and then that's when it started to cut out.
Okay. Let's just start there, Mr. Wentz.
Of course. Well, as you mentioned, he was screaming and becoming belligerent, so I actually asked him to step out of the vehicle.
And did he step out of the vehicle?
Well, he did eventually, but when he did, he changed, kind of.
Officer Wentz, what do you mean by this?
Well, before, he was frantic, screaming and yelling about the CIA, but after he got out, he appeared sedate almost. He was just had this blank stare, and he was almost looking through me. Just kind of kept muttering, not to me.
I'm sorry, was there an objection?
Yes, Your Honor.
All right, let's move outside the presence of the jury. Your grounds?
For speculation, because this witness's answers has included almost or seemed like frequently, and so therefore he's speculating.
Maybe heard
Mr. Barrett? Yes.
Your Honor, he's testifying to what he perceived based off it's a rational perception based off his five senses. Hear what he saw.
I agree. Objection's overruled. You can continue, Mr. Barrett. We're back inside the presence of the jury.
So what was he saying at this point when he had this blank stare?
Well, at first I couldn't be sure. He kept just muttering to himself over and over again. Eventually, he looked up at me like he hadn't noticed me before and said, I was just trying to get my son in shape and get him to admit what he broke. My son just needs to do jumping jacks?
What happened after Mr. Ray said all this about jumping jacks?
Well, then he started doing a jumping jack. I told him to stand still, but it didn't seem like he heard me. He started doing another and another. At this point, I had no idea what he would do next, so I actually pulled my gun and I yelled at him to stop.
Did he stop?
He stopped doing jumping jacks.
What happened after this?
His head just started moving uncontrollably. He was holding his hands over his ears, and he did that until I was finally able to get handcuffs on to restrain him. But then he did that rambling again in that same quiet, frenzied voice.
Officer Wentz, what did you do after seeing all this?
Well, at that point, my partner called me over. So I sat Mr. Ray down on the curb just a few feet from the patrol car. My partner said the plates on Mr. Ray's car had flagged on a missing child report. So I had my partner keep a close eye on Mr. Ray, and I went to radio it in. I described what happened, and I expected dispatch to send us an EMT.
Who'd they send?
Well, about 20 minutes later, Detective Booth arrived on the scene.
What did Detective Booth do when he arrived on the scene?
It was strange. He told me to escort Mr. Ray to the station and get him set up in an interview room for an interrogation right away. I thought there would be an EMT called in so we could get Mr. Ray to a hospital.
Officer Wentz, what did you end up doing?
I followed orders. I put Mr. Ray in the back seat and then drove him to the station, then straight to the interrogation room, just like Detective Booth told me to do.
Thank you. Nothing further, Your Honor.
All right. Mr. Green, your cross.
Yes, Your Honor. Officer Wentz, you stated that on direct, the defendant had actually, and I wrote it down, he had kind of looked like he'd been in his car for days.
That's correct. It's impossible to tell for sure, but that's what it looked like.
But this isn't surprising because you later learned the defendant was in his car for 3 days riding around with Nathan's corpse.
I got some details of the investigation, so it turns out my initial assessment was right.
And back to my question, so that was a yes.
Well, it didn't surprise me, so I guess no. But you're correct.
And you discussed the interaction that you had with the defendant, and he actually lied to you about having his ID and vehicle registration, correct?
Yes, he did.
And you discovered these items after he lied and said he left them at home.
Yeah, I discovered them. I mean, they were sitting right there. It would be kind of hard not to. But yes, you're right.
And this is the defendant who had just murdered his son.
Objection, Your Honor. Mischaracterization may be heard.
Yes, you may. Let's move outside the presence of the jury.
Your Honor, the opposing counsel just said murdered his son. That's what we're here today to determine. You could say killed, but murdered is going too far.
Yeah, I'm gonna sustain that objection.
Well, the defendant had just killed his son, correct, officer?
Well, as you mentioned, it'd been a couple days, and I didn't know that at the time. But yes, he had killed his son just a couple days before.
So after he had murdered his son and lied to you about having his ID,
Yes, Your Honor. Mischaracterization. Maybe.
I think the witness misspoke. So I'm going to sustain the objection. Let's stay away from the use of the word murder.
Yes, Your Honor. So Officer Wentz, it was only after his son had been killed and he lied about having this ID, that's when you describe him as being frantic.
Yes, that's correct. Your timeline is correct.
And this is the man who you would later discover was the suspect in a missing persons report.
That's right. My partner told me that during the traffic stop.
And this missing persons report involved 6-year-old Nathan Ray, the defendant's son.
Yes, sir.
And so upon finally getting the defendant's ID and registration, you glanced in his car
Yes, I did.
and you saw a shovel,
Yes, I did.
you saw a ton of trash bags,
Several boxes. Yes, sir.
you saw 2 jugs of bleach,
That's correct.
and you saw what appeared at the time to look like blood.
That's right. I wasn't sure at the time, but I suppose it's possible.
And you weren't sure at the time, but it was later tested and found to be the blood of 6-year-old Nathan Ray.
I'm not sure on the specifics. I wasn't involved in the investigation after that night, so I'm not sure.
So it would surprise you that in this case, in this individual that you arrested, you have no more knowledge of what happened after that?
Well, I wasn't the investigating detective. I simply pulled Mr. Ray over. I didn't conduct any of the lab tests or do the investigation.
And
I wouldn't say that it would surprise me.
And in this case that you were involved in, that blood was discovered to be the blood of Nathan Ray, correct?
Objection.
I believe.
Knowledge. Have you heard?
Yes, outside the presence of the jury. What was your objection? I missed it.
A lack of personal knowledge. Officer Payton once just explained that he was just the one who made the stop. He didn't really have too much involvement afterwards.
If I may respond, Your Honor, this officer was involved in this case. It's unreasonable that he just has no idea what happened after, specifically with this blood, when he seems to remember other things.
Maybe.
All right, well, hold on one second. Mr. Green, why don't you just lay that foundation that he has that knowledge, and we'll go from there. So I'll sustain that objection for now.
Any answer given stricken, Your Honor?
Yes, back inside the presence of the jury.
You're an officer involved in this defendant's case,
Yes.
and you're familiar with the facts of why the defendant got arrested.
I'm familiar with the defendant's actions on the night that I arrested him. That's why he was arrested. Yes.
And that blood was later determined to be the blood of Nathan Ray.
Objection on lack of personal knowledge.
Well, outside the presence of the jury, let me just ask Mr. Wentz. Officer Wentz, do you know whether or not that blood was determined to be the blood of Nathan Ray?
I'm not familiar with that, Your Honor. I don't remember that test being run.
Okay. Mr. Green, I'll give you the last word. If you have any other arguments or questions that you want to ask to lay foundation for Officer Wentz in your cross to get the evidence that and the testimony that you're attempting to elicit, I'll allow it. But otherwise, I got to sustain the objection for right now.
Yes, Your Honor, I'll continue. Officer Wentz.
Excuse me.
So
We're back inside the presence of the jury. Sorry. Go ahead, Mr. Green.
So Officer Wentz, after the defendant, you had caught him in a lie, you had identified him as being Timothy Ray and discovered these items in his car. That's when he accused you of being with the CIA.
That's correct. You're right.
Compound.
All right, let's move outside the presence of the jury again. Your objection was compound?
Yes, Your Honor.
Okay, overruled. Mr. Green, continue.
So I asked that question again. It was only after that you had caught the defendant in a lie, identified him as being Timothy Ray, and discovered these items in his back seat when he started accusing you of being in the CIA.
No, it's not quite correct.
So you did catch the defendant in a lie.
Well, yes, he told me that he didn't have his license, and obviously
and
he did.
after you caught this defendant in a lie, you discovered the items in his back seat.
That's correct.
You identified him as Timothy Ray.
No, see, I went back to the car and he accused me of being in the CIA before my partner ran the license. I only learned that he was Timothy Ray afterwards.
And that's fine, officer. So you're saying you never looked at the ID or vehicle registrations to see the name Timothy Ray? You blindly handed it to your officer?
Oh, that's correct. I did know that it was Timothy Ray from the ID. I didn't know anything about the missing report, the missing child report. I apologize. I misunderstood you.
So you caught him in a lie, identified him as Timothy Ray, and found these items in his backseat, and that's when he accused you of being in the CIA.
That's correct.
But he never accused you of being in the CIA when, at the beginning of your interaction, when you were asking for his ID.
No, he did not.
And he understood your questions enough to lie to you about them.
Objection on speculation.
Overruled.
I'll ask that again. He understood your questions enough to lie about them to you.
Apparently so, yes.
And then you instructed him to get out the vehicle?
Yes, I did, after returning to the vehicle.
And you stated he changed his behavior?
Yes, that's correct.
But you never called an EMS to the scene that day.
No, I called dispatch and asked them to send somebody.
And back to my question, you never called EMS to the scene that day.
No, I did not.
And in fact, you escorted the defendant to the police station where he was charged and arrested with the murder of 6-year-old Nathan Ray.
That's correct.
No further questions at this time, Your Honor.
All right, any redirect?
Please.
Mr. Barrett, I had a little bit of a technical glitch on you there. Any redirect?
No, Your Honor. Can you hear me?
Yeah, I can hear you. All right, so no redirect. All right. All right, so this witness is excused. Officer Wentz. Any other witnesses from the defense?
No, Your Honor. With that, the defense rests.
Okay. Let's go ahead and take up some motions. Do we have any motions?
Your Honor, if we could just constructively have a motion to exclude the jury charge stating that this defendant suffered from, or that we asked that it be excluded from the jury charge, the guilty by insanity. And we just want to make that motion constructively because of time.
Okay. Well, I'm not timing you on your motions anyway, so I'm going to, we will make that motion. I'm going to deny it because I'm not messing with the jury instructions. Okay.
Yes, Your Honor.
Mr. Hitchcock, anything from you?
No motions, Your Honor. We just asked for a time check before we go to closing. So if we're getting a break.
Let's absolutely let's get time checks from both sides. I guess what we're working off of was the defense time last time. So let me hear from the defense since we started with you last time. You had the state at 23 minutes and 35 seconds remaining. What do you have them out now?
Your Honor, we have both timekeepers have the state with 8 minutes and 39 seconds left.
And that was both timekeepers, you said?
That's correct. We've been able to make sure that the timing is accurate between the two of us.
Okay. And for the defense?
For the defense, we have 11 minutes and 27 seconds left, Your Honor.
Okay. And both parties are agreeable to this time. So there's no objections or anything that we need to take up with that?
That's correct, Your Honor.
All right. Do y'all want a quick couple of minutes before we start with closings?
Ready? Does the defense want to take a break or anything?
We're fine either way.
All right. Well, let's go ahead and get going then. Mr. Hitchcock?
I believe prosecution goes first.
Oh, I'm sorry. You are on the defense side. So, Mr. Green.
Your Honor, if I could request to have 1 minute for rebuttal time?
Yes, we will reserve 1 minute of rebuttal time. So that would give you 7 minutes and 35 seconds with 1 extra minute for rebuttal.
And could I request that my timekeeper not say anything, but merely just pop on the screen when it gets to a minute of the allotted time I have for close?
I'm okay with that. And if the defense wants to do the same thing, I'm also okay with that.
Yes, Your Honor. May it please the court, opposing counsel, members of the jury. Help me. Why are you doing this to me? I want my mommy. I want my mommy. That's a phrase that all of us can imagine saying as we were children. But I want my mommy. Now we know that was the last thing that 6-year-old Nathan Ray said before his father, the defendant, proceeded to grab a belt, place it around his neck, and squeeze and squeeze and squeeze until 6-year-old Nathan was lifeless and could no longer call for his mommy ever again. As the representatives of the state in this case, we've been seeking justice for 6-year-old Nathan Ray throughout this trial. But not only Nathan, but for Jessica Ray, his mother too, who is in the courtroom with us today. Because she's a victim too. No mother should get that call that their baby has just been found, dumped out in the middle of the woods, stuffed in a trash bag, dead. And no mother deserves to have to bury their own baby. No mother deserves to sit through a court proceeding having to look at the man who took her baby from her and relive the experience through each and every witness we call. That's why we accepted the burden today of proving to you all that beyond a reasonable doubt, the defendant murdered 6-year-old Nathan Ray and intended to do so with malice aforethought. The defense, since they're raising an affirmative defense of insanity, they have burdens too. They have a burden. And that burden is to prove to you by clear and convincing evidence the defendant did suffer from schizophrenia at the time he murdered his son. However, we know they won't meet that burden because they have not presented any clear and convincing evidence in this case, because their case doesn't make sense. It doesn't make sense for the defendant to murder his son and then proceed to Google how to get rid of a body and attempt to get rid of that body. It doesn't make sense he had schizophrenia at the time he murdered his son, because after he Googled, will bleach destroy a corpse, and was found with bleach in his car. It doesn't make sense that he suffered from schizophrenia at the time, because he grabbed a belt, sat and reflected on his actions before eventually going in to strangle his son. And let me remind you, he didn't accidentally shoot little Nathan in the middle of a psychotic breakdown. He didn't accidentally slit Nathan's throat. This man strangled his 6-year-old son with his own hands and the belt. So who knows how long Nathan was screaming for his mommy that day? Who knows how long Nathan was trying to get away from the defendant with that belt around his neck? And who knows how long it took for little Nathan to finally die? And we know that's what happened that day because we called Detective Booth, and she told you the defendant confessed to doing these things. And she, after receiving this confession, she went to the crime scene. She saw the laptop with the juice on it. She saw their home, and she saw Nathan's room with the murder weapon, a belt, laying in the middle of the floor. And then she told you that she continued investigating, and then she found Nathan's body out in the middle of the woods, stuffed in the bottom of a black trash bag like he is garbage. And this all matched up with what the defendant had told her, what he had remembered happening specifically on that day. And then, if that wasn't enough, he had Googled how to get rid of a body, will bleach destroy a corpse, and which countries don't extradite for murder charges. This defendant knew what he was doing when he murdered 6-year-old Nathan Ray. He knew what he was doing. And we had our forensic psychiatrist testify for you today, and she told you he knew what he was doing, and he was malingering. He was lying. He didn't have schizophrenia, and he didn't have schizophrenia when he strangled Nathan Ray. And she said there was even more evidence of malingering, including the interaction with Officer Wentz. Because at the beginning of the defendant's interaction with Officer Wentz, he was fine. He understood the questions the officer was asking him, and he understood them well enough to lie and say, I left my wallet at home. I don't have my vehicle registration. But luckily, Officer Wentz found these items and identified him as being Timothy Ray. And then Officer Wentz found items, bleach, a shovel, and trash bags, and blood, Nathan's blood in the back of the car. And it was only after all these items were discovered and the defendant was caught in a lie when he started to accuse people of being in the CIA, when he started to do jumping jacks and move in slow motion. It was only then. And the same goes for Dr. Riley. Our expert told you this was evidence of malingering because Dr. Riley saw the defendant in 2010 at a time Dr. Riley was employed by the Army. And during this evaluation, Dr. Riley said the defendant had generalized anxiety after observing him for 3 days. She concluded he wasn't a harm to himself or anyone else and released him to the public. But it's only now, in their 2019 interview with the defendant and Dr. Riley, when I will remind you, Dr. Riley was getting paid by the defendant, that's when she determined he had schizophrenia. And if you remember, my co-counsel on cross-examination was asking her about the 2010 interaction, but she couldn't remember that one. She didn't even remember how long it lasted for. But then they want to call her to testify to you about this man's medical records and mental state, even though she said she reviewed all the evidence? It doesn't make sense, ladies and gentlemen. This defendant wants you to believe he suffers from schizophrenia, but I'll tell you, this is the same defendant that would strangle his son. This is the same defendant that after strangling his son would stuff him in a trash bag and dump him out in the woods, hoping nobody discovers it. And this same defendant that wants you to believe he has schizophrenia would come in front of the people he took Nathan away from and try to convince to you that he has schizophrenia. They can't even mourn Nathan's death because of the defendant's actions. Nathan Ray deserves justice. Jessica Ray, his mother, deserves justice. And we ask that you give them that justice by finding the defendant guilty of murder in the first degree. Thank you.
All right. Defense ready to give their closing statement?
Yes, Your Honor.
All right. Ready when you are.
They miss the signs. Timothy Ray is sitting in a waiting room. Again, same curtains, same clock, same problems. The voices, the negative thoughts, the family issues, it's becoming unbearable. He knows something isn't right. It never has been. He just doesn't know what. He hopes maybe this doctor will finally give me an answer. But an hour later, he leaves without one. Year after year, Timothy Ray books another appointment, sits in another waiting room, and sees another doctor. But year after year, no treatment, no diagnosis, and no answer. And his problems don't just go away. No, they get worse. And eventually, it's too late. Mr. Ray's schizophrenia took over. Nathan is gone because they missed the signs. And today, the state's charged Mr. Ray with first-degree murder. And normally, the burden would be on the state, but we aren't disputing what happened to Nathan today. Instead, today's case came down to our affirmative defense of insanity. This defense exists because sometimes people do terrible things, but because of mental illness, they don't realize what they've done. So while the law says there must be consequences, those consequences aren't criminal. Now, with this defense, we do have a burden, but it's not beyond a reasonable doubt. Our burden is the much lower standard of clear and convincing evidence, simply meaning much more likely than not. And to prove our insanity defense, we had to show two things. One, that Mr. Ray has schizophrenia, and two, that schizophrenia caused Mr. Ray to lose control and harm Nathan. I'll take those one at a time. First, we've proven that Mr. Ray has schizophrenia. Dr. Riley, the only medical professional you heard from who ever evaluated Mr. Ray, gave sworn testimony she is confident he is suffering from schizophrenia. And we heard the reasoning behind this diagnosis. While a diagnosis of schizophrenia is medically sound under the DSM if someone shows 2 symptoms for a month, Mr. Ray had been showing 3 symptoms for years, some dating back to his childhood. He would have negative symptoms, strange and erratic behavior, locking himself in the bathroom and changing his mood at the drop of a hat. He would have delusions, paranoia about his wife and his son conspiring against him to hurt him and to leave him. You heard on Dr. LaGreca's cross-examination that she agreed he was experiencing paranoid episodes about his doctor. And then he had hallucinations, seeing strange shapes in the world that weren't really there, and hearing voices telling him to do horrible, horrible things. The prosecution, they want you to believe that you can't trust Dr. Riley, that she's just some hired gun. But her investigation was thorough. Clinical interviews, the best practice in the field, and something the state psychiatrist never did. She reviewed every piece of evidence in this case, and if that's not enough, she conducted 3 additional interviews with people who know Mr. Ray intimately. His wife, who reported years of antisocial behavior. His boss, erratic mood swings at work, and his father, the family history of mental illness, all corroborating that Mr. Ray's symptoms before Nathan died were real. This is how we know that his symptoms exhibited after Nathan died are those of schizophrenia. You heard from Officer Wentz about the CIA accusations, the erratic head movements, the talking to himself, and the jumping jacks at a traffic stop. There's the interrogation with Detective Booth, again with CIA accusations, this time bringing up the voices and the conspiracy. They told me to, without explanation. And again with Dr. Riley in that clinical interview. Again, CIA accusations, again, voices, again, conspiracy. In this interview, Dr. Riley saw the signs. That Mr. Ray's behavior isn't normal because Mr. Ray isn't normal. He's schizophrenic. This brings me to my second point, that on the day that Nathan died, Mr. Ray's schizophrenia was so severe he didn't know right from wrong. Now, a moment ago, the prosecution came before you and reminded you of the gruesome and horrific details of October 17th, 2018. How a loving father suddenly did the unthinkable by using a belt to strangle his 6-year-old son, all over spilled juice. Members of the jury, I bring this up because these details are shocking and horrific. But that means that they're evidence that Mr. Ray was insane, because sane people don't kill their kids. Remember, there's no history of abuse, no desire to harm. No, instead, Mr. Ray was trapped in his own mind. Voices, hallucinations, delusions, it caused him to lose control. Now, the state brought you some Google searches, and they want you to believe that these show he knew right from wrong when he killed his son. Except they don't. Because these Google searches happened the day after Nathan died. Think about that for a moment. Why would Mr. Ray commit a heinous crime that he knew he'd be the obvious suspect for without thinking about how to get away with it beforehand if he wasn't insane? He wouldn't. All these searches show is that Mr. Ray realized what had happened after it was too late. Now, you may be thinking, this doesn't make sense. How could someone be legally insane and then realize what they'd done and then start experiencing schizophrenic symptoms again? But members of the jury, that is exactly why this defense exists. Because Mr. Ray hops in and out of schizophrenic episodes based on triggers no normal person can understand. Schizophrenia isn't supposed to make sense to those of us who are lucky enough not to suffer from it. But it's the disease that chooses when to be in control, not the person. Today, the state made their case about malingering, claiming that Mr. Ray is faking his symptoms. Their expert who came to that conclusion, Dr. LaGreca, well, she didn't treat Mr. Ray, didn't meet Mr. Ray, didn't ever see Mr. Ray's symptoms for herself. Yet, they want you to believe her. But none of us get that chance. We could have. There was a recording, but we don't have it because the detective decided not to preserve it. She chose to let it get deleted. Why would she make that choice? If someone had just confessed to killing another person, wouldn't you want to keep that evidence? So ask yourselves, what was in that recording? No, really. What would it show? Was Mr. Ray screaming? Was he crying? Moving or shaking? Did it seem like he was talking to someone who didn't really exist? We'll never know. Well, the detective wants you to think that you could trust her. She was there. But members of the jury, you were in trial today. You know the detective changed her story because hindsight's 20/20. I guess it's a little odd. Why wouldn't the detective want you to see this for yourself? Well, that's pretty clear. It's because the detective saw the signs. The detective knew Mr. Ray wasn't okay. But because she thought Mr. Ray is a piece of shit who would be better off dead, that's right, quote, a piece of shit who would be better off dead. She couldn't let you see the signs for yourself. Members of the jury, I want to make one thing clear. Finding Mr. Ray not guilty by reason of insanity isn't some magical get out of jail free card. Instead, it means giving Mr. Ray treatment he should have received long ago if doctors hadn't missed the signs. See, convictions are for people who do wrong and mean it, guilty hands and a guilty heart. But Mr. Ray isn't evil. He's sick. And while there may be blood on his hands, there isn't evil in his heart. Mental illness is not murder. Members of the jury, this is the jury verdict form. In a few moments, you'll leave to go begin your deliberations in this case. And when you do, we ask that you choose to treat Mr. Ray for his disease and not punish him for being sick. We ask that you find him not guilty by reason of insanity. They missed the signs. You don't have to. Thank you.
All right, Mr. Green, a very quick rebuttal from you.
Yes, Your Honor. Defense mentioned the defendant in medical appointments with the same curtains, the same clock, but forgot to mention the same doctor, Dr. Riley. That's who missed it. A person they brought to testify to you about schizophrenia, but she couldn't even remember her own evaluation of the defendant. But the defense did get this right. The defendant is not normal because he's a killer. And therefore, because he's a killer, he does not deserve to be out here with the rest of us. So I ask you find him guilty of first-degree murder for his acts of murdering 6-year-old Nathan Ray.
All right. Thank you, Mr. Green. Judges or jurors, please go ahead and complete your ballots. And I'll ask that everyone just stay on until everyone has submitted their ballots, and then we'll do some brief comments. All right. And our jurors, judges, if y'all could let me know that you have completed your ballots, either by just popping in, letting me know, or let me know in the chat.
Jim, I just submitted mine. Thank you. Everyone did a great job. Good luck.
What's the defense team number?
Defense is 108, I believe. I just submitted mine, so I didn't see it. I think it's 107 for prosecution, 108 for defense.
That's right.
I submitted as well.
All right.
So, Judge, we're free to sign off?
Well, 1 second. Let me get have y'all all submitted your ballots, I'm guessing now?
Yeah, I got my numbers. I'm just putting them in. I printed it out.
1 second before you go. While you're completing that, if I could get all of the advocates back, please. And we'll just wait for that final okay on that last ballot.
Okay.
All right, thank you. All right, all the ballots have been submitted. We will do some brief comments now for the attorneys only. And because we have so many judges and we want to give the attorneys time to prepare for their next trial tomorrow, I'm going to ask each judge to limit themselves to one comment, either their favorite moment from trial or one suggestion for one of the competitors. And I know that one of our jurors had to sign off early, so I think we just have 2 people giving very brief comments.
I'm actually still here, but I can go quickly if I'm able to
Okay,
go.
great.
Should I go on my camera or no?
You're certainly welcome to, absolutely.
Okay. Hi, everyone. Great job, everyone. If I have to pick, let's see, one thing that I'll say constructively for the state, in my opinion, the sort of gesturing during the description of the strangulation is a little hard to take in this case. I think that cases involving children are just a different beast, and you have to go have a little bit of a gentle touch, or it can be very jarring. Let's see, in terms of the something I thought was really great, pointing out the potential bias of the change in the defense expert's opinion over time and how that correlated with the payment as an expert was excellent. In terms of the defense, I think that focusing on sickness as a theme was very good, a way to humanize a really difficult situation and contextualize it in kind of the only way you can to make your client sympathetic in this situation. In terms of one other thing I'd say, one constructive comment I would say is kind of don't give things away too much. Like when you're asking your expert on qualifications about being payment, don't say like, you know, in the interest of full disclosure, as though you're kind of signaling to the jury maybe you're eliciting something that's not quite kosher, but it's perfectly acceptable to be paid as an expert. You're being paid for your time, your expertise, and you're doing a job, so that's completely fine. I think you did a really good job with both of you, and the defense did a really great job with your objections. And even when you're having a judge that you know is going to deny it, don't open it up by saying, I know you're going to deny it, just renew your objection. Those are my comments. Great job, everybody. Bye.
Thank you, Ms. Palmer.
Hello, everyone. Jim Waldenberger. First thing I want to say is bravo to everyone. Great job. The level of preparation that each of you put into this was impressive. The way that you conducted yourself was impressive. So please, keep that in mind when I'm just going to give some brief constructive criticism. And this isn't easy what you're doing, and there's no hard and fast rules of a right and wrong way to do it. So it's really about style. And so keep that in context when you hear anything that I'm going to say as far as criticism, let alone whatever anybody else is going to say. But for me, across the board, I felt that there was a little too much over the topness. I thought, for example, the very dramatic in opening and closing the prosecution, reenacting the strangulation, the very dramatic in raising the voice with the squeeze, squeeze, squeeze. It was actually cringeworthy for me. And at one point, it made me just feel uncomfortable, not in the sense that, oh, I don't like thinking of the imagery. It just the way that it was performed just was not very comfortable to watch. So I know that's a little on the harsh side, but I just say that because I think that maybe in the next few rounds you tone that down and convey the same message, because it was just, I liked what you said, the manner in which it was delivered, and the fact you did it in open and in close, for me, just punctuated it twice. But keep the message, I would tone it down. And then similarly with the defense, I get the whole piece of shit thing. I agree with bringing it up, but there's only so many times you have to say it. I'm from Philadelphia. We curse all the time. So it's not an issue with the actual profanity. The issue is at some point in time, it stops looking like argument and it just looks like you are showing off or wanting to emphasize something that is, I get, not a very good thing for the cop to say, but the fact if you keep hammering it, it I believe loses its effect. On a positive note for everybody, I thought the cross exams were very good. You got to the point, you figured out what the point of the witness was, and you attacked. I thought all of your direct exams were very well structured. And kudos to the prosecutor who figured out that the witness was reading notes. I thought that was impressive. So to everybody, I wish you the best of luck in the tournament. You did a great job, and good luck in your school and professional careers.
Thank you. All right, our last juror.
Can you guys see me? Nope, you can't. There we go. Good job, everyone. What I want to echo what Juror Waldenberger had said. Everybody's preparation for today was apparent. Nobody didn't know the facts, if that makes sense. So first, I mean, that's sort of the baseline, but all of you had met and exceeded that in a lot of areas. My general notes are, again, echoing something that others have said, is jurors are watching you. They're watching your face, they're watching your body, and I think, you know, everybody has their own style, but you just got to be cognizant of what you're trying to do. And if you're trying to testify by your face or your hands or your body language, that sometimes turns people off. And so I would echo the comments, just be careful how you're presenting, because at the end of the day, while jurors are watching the witnesses, they're also watching you. The crosses I thought were good. I thought it could be tightened up a little bit. Avery, I thought you did a great job right off the bat. I mean, it was like the fireworks of the trial for me is going right after that witness first question. I thought that was great, and I'd encourage others to do the same. And that's what we do in our cases and in depositions, is hit them with something that they're not expecting, that the jury's going to perk up, and that's the only thing I remembered from that cross. So that can go a long way. I thought the defense had a tough case to prove, even though it's not typically the defense's job to do it. Thought you guys did well. And from the prosecution, I thought everybody did a good job. The closing for me was particularly good, and I thought you did a bang up job crossing their expert, who was their only real witness in the case to give their testimony. So overall, very good job, guys. Good luck this weekend, and glad to be a part of it.
Thank you. All right, guys, I will keep my comments short. Obviously, I'm one of the coaches that has a team competing here, and I know how much y'all have had to probably put into this. This is not difficult doing this stuff over Zoom. I was a trial ad kid here as well, and I can tell you that this is a lot harder to do than actually being in a physical courtroom. So I commend you on your efforts. I thought the tech went very smooth. I mean, I thought y'all handled that very well. I will say, don't take any stock in the way that I ruled and any objections. I would not consider that one way or the other. I'm probably a self-described evidence nerd, but I don't want to gut one side of the case. I do appreciate the arguments, and I very much do consider those if I was scoring. But I want to see how people handle objections, and that's more important to me, and want to be able to see the case that you prepared. So I say that, don't take any stock into my rulings. But otherwise, guys, I thought you guys did great. This was very competitive round for me. Obviously wasn't scoring, so it doesn't matter what I really think. So I know y'all are tired, probably ready to get going. The only thing I will mention, just as a helpful hint to the state, y'all's camera setup is like a little tilted, and you have behind you, you have those straight up and down lines. So it almost kind of looked like you were a little tilted. It wasn't extreme. I just say that because I noticed it. So I would just make sure your tech is, or your camera is level. But other than that, guys, great round. I commend all of you and your coaches as well. This is a great round. So with that, I think we are done. You can sign off.